Yes, electricity.
Yes. But in the second half, my lord, I'll be held up in a division bench, my lord. That is, my lord, I'm continuing addressing the court. Could your lordship, my lord, keep it, my lord, day after tomorrow, my lord? Somebody will be here to, my lord, respond at the time of call, my lord.
Sure. You're for the appellant,
Yes, I am for the appellant.
not today and tomorrow. Thursday. Thursday. Who's on the other side, Mr. Advocate?
Mr. Obrotosh Mozumdar is there. Therefore, my lord, I am requesting, my lord, kindly, my lord, pass this order, my lord, at the time of call.
Yes, এখন কিছু করো না, ডাক হলে মনে রেখো।
Milord, may I be permitted for inclusion of a bail in connection with appeal?
Inclusion, just hand over. Hand over.
My lord, I'm mentioning one. My lord, I'm mentioning one appeal before your lordship. This is an appeal of 2019. More than half of the years has been served. I'm mentioning for inclusion.
He said for inclusion, just hand over. Yes, Mr. Shawn.
With your lordship's leave, Lord, one Port Blair matter, Lord, the appeal. Port Blair Municipal Corporation made a unanimous resolution for extension of the lease. That was not acted upon. The secretary issued an order for tender. We challenged it. The learned single judge disposed of the matter, saying that no, proceed with the tender.
When was the impugned order passed?
Lord, we have the certified copy. Recently, we have received it, Lord. The urgency is this, Lord, that it's a pure question of law. I'll hardly take 5 minutes of your
No,
lordship's
Mr.
time.
Shamantu, the bench was available till yesterday.
That's right, Lord. But then we couldn't because of the difficulty, Lord. We have to draft the petition on all those things.
When was the impugned order passed?
The impugned order was passed on 29th
Of?
but we received the certified copy because without certified copy, the holidays were there. The holidays were there.
Your
As
clients were not diligent enough. Anyway, file it, file it.
Lord, leave so that it can be. And may it be taken up.
We have the determination.
Yes, your lord, because Port Blair, your lordship will be having the determination of
which group?
Group 9. Lord, may it be taken up day after tomorrow. I have served notice. I'm grateful. I'll hand over a slip to your lordship's court officer separately. At a slip the other one.
But may I be permitted to mention one matter for to leave may be granted to file this matter without certified. This is an intra-court appeal.
When was the order passed?
But the order was passed on 24th of October 2025. That is the day opening after the vacation. And this was the Group 9 matter.
Lord, out of 10 years, 8 years has been already passed out in the. So we have mentioned this matter. It's a case under the NDPS Act. If your lordship kindly fixes a date any.
Your junior just now mentioned it. So you are mentioning it second time.
Lord, I'm very sorry. I was not aware.
Well, may I be permitted to mention this appeal? Well, the appellants are languishing in jail since 2011. But it is that matter. But
what do you want? Inclusion? What do you want?
Inclusion.
Give it, give it.
Milord, may I be permitted to mention a matter, Milord? This is this matter, Milord, is a Group 9 appeal.
Inclusion under what? It's a suspension of sentence. Okay. You have a. Just see.
No. It's a hearing, appeal hearing.
Criminal appeal, criminal appeal.
Hearing.
All right.
Milord, this matter was.
উপরের দিকে দাও তো বলছে কি 2011 থেকে জেনে যাচ্ছে উপরের দিকে দিই এটা বললো মুখ করলো দেখি ওটা ও সেই ডিপার্টমেন্ট yes.
Milord, the appeal was directed to appear today, Milord. On 7th was taken up on the 7th on Friday. This
what appeal?
It's a Group 9 appeal, Milord.
Now, you know.
The order is also not uploaded, if Milord could kindly.
Mentioning slip. Which order? What order?
My lord, this matter was taken up on the 7th, which is last Friday, and the affidavit in reply was taken on record, and directions were passed for the matter to appear today, but that is not appearing in the list.
কেন নেই আপলোড হয়নি কেন
And the order is also not uploaded.
দেখে নাও এক্ষুনি তো দেখতে পাবে কম্পিউটারে মারলে কোথায় গেল কৌশিক বাবু কোথায় গেল মায়ের ক্যাটারেক্ট অপারেশন আগে কে আছে আপনি কোনটা দুটো দেখ তো
এটা ইনক্লুশনের জন্য
যদি হয়ে থাকে এইটা।
7/11/2025.
We'll look into it.
My lord, I beg to mention one matter for withdrawal of the appeal, my lord, 2021, my lord.
Criminal appeal? The
Yes,
Group 9.
My lord,
Group 9 appeal or criminal appeal?
criminal appeal, my lord.
You have written
2020.
instruction. You have written instruction.
My lord, I have taken instruction from my senior. My lord, instruction is, my lord, I have taken, my lord, from the client, my lord, my senior has taken, my lord. Lord, let the matter come at least then.
Appeal against acquittal.
Yes, my lord, I don't know, my lord, that is.
If you don't know, then don't mention, sir. You should know the basic things.
How do you know your problem?
My lord, my senior instructed me to mention.
Call your senior.
How long have you been in practice?
My lord, 1.5 years, my lord.
1.5 years. That's the problem.
Who is your senior?
Mr. Rabiul Islam, my lord.
So he should have.
Ask him to come. Ask him to come. Tell him we want him to come.
Your Lordship, may I have the kind leave to mention a matter? Your Lordship, the paper book has been completed for urgency, Your Lordship. If I can kindly.
Group 9 criminal, what is
Group
it?
7, Your Lordship.
Group 7. We don't have Group 7 determination.
Apology, Your Lordship. Group 6, Your Lordship.
We don't have Group 6 either, sir.
May I please?
Apology.
May I please permit and mention criminal appeal for non-prosecution.
You have written instruction.
I have written instruction with me.
To be mentioned, to be mentioned tomorrow.
To mention tomorrow. File is not in this court. File may be in court number 26.
Appeal of which year?
2021.
File tani now.
My lord, may I be permitted to mention one bail in connection with that?
Inclusion, give it.
Item number 1.
Item number 1, I am for the applicant, my lord.
Why is it appearing as to be mentioned, madam?
Actually, it's a status report from the
Oh, I see.
government.
I see. Likho. From a departmental note dated November 10, 2025, we see that the TCR in connection with the instant appeal have been records too, have been received, examined and found complete. Stop. The department seeks 6 weeks time to prepare the paper book. Such time is granted. Paragraph lists the matter. Now, let the matter appear in the monthly list of January 2026 or 26 or 27?
2026.
6.
Hey, sleep then, sleep down.
Status report. Vicky. Same order. Departmental note of 10th of November, same order, same order. The department seeks 6 weeks time. We are granting that time for filing paper book, preparing paper book. Monthly list of January.
Item number 3.
Abhijit, same order accepting departmental note টা হচ্ছে November 7. ঠিক আছে?
Same order.
No, nobody appears to করে দিও। Nobody appears.
My lord,
For either.
my lord, if your lordship allow me, my lord.
Which one? 83?
No, my lord. That mentioning, my lord, I have taken instruction, my lord. If your lordship allow me, my lord, may I hand over the slip, my lord? That instruction from the client, my lord, that written instruction is there, my lord?
Is there.
Yes, my lord.
Therefore, give the number. It will be listed as to be mentioned tomorrow.
Yes, my lord.
Give the number of the appeal. Bring the written instruction tomorrow when the matter is listed.
Number
to be mentioned unmentioned.
I'll come back with my instruction, my lord. Wait.
Anyway.
For I am the appellant. Your lordship, sir, please to call for a status report from the department. No, I think the paperwork is ready.
ওইটা এইভাবে অভিজিৎ এটাও ডিপার্টমেন্টাল নোট November 7, 6 weeks time, monthly list of January.
এটা নো আছে
শোনো 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 দুই পাঁচ থেকে এই রেলে লাগে 20 সেকেন্ড
Item number 5. Item number 6. Item number 7. Item number 8. Item number 9. Item number 10. Item number 11. Item number 12. Item number 13. Item number 14. Item number 15. Item number 16.
second call
Item number 17. Item number 18. Item number 19. Item number 20. Item number 21. Item number 22. Item number 23.
second call
Item number 5.
এসো অভিজিৎ যেটা ওল্ড ম্যাটার যেগুলো করো this is an old appeal of very old appeal of 1959. The appellant has taken no step, not interested. Paragraph. In the first call, nobody appeared for the appellant. Stop. In the second call, also, hey, তুমি বারবার বলছো. In the first call, nobody appears.
appeared.
In the second call also nobody appears. It appears. Paragraph dismissed entry order.
Yes, yes,
Item number 6,
Same,
item number 7,
same,
item number 8,
same. These are, Mr. Shorka, these are appeals of 1959.
item number 9,
We have searched it out.
item number 10,
Nobody will come.
item number 11, item number 12, item number 13, item number 14,
15 থেকে এটা
item number 15,
not today, নেই তো। Admission, কেউ নেই।
15.
So no advocate.
Item number 16,
It is no advocate. তাহলে কি এটা আমরা কাউকে
ও 15 টা no advocate.
হ্যাঁ সেটা বলছি তাহলে যে আমরা কাউকে তো করতে হবে অ্যাপয়েন্টমেন্ট করতে হবে
নাম নেই নাকি?
না না
আমরা
এটা jail act.
15 টা করো।
Item number 15,
Legality কে করতে হবে appointment করার জন্য আমরা সেটাই ভাবছি সেপ্টেম্বরেও কেউ আসেনি এটা আমার মনে হচ্ছে দিনের বাজেট একদম পেছনের ভদ্রলোক চাপ দেবে বুঝাবে এই দুটো ব্যাট শিবাশ্রী রায়কে দেখে নেয় ঠিক আছে একদম কাউকে শিখিয়ে দিচ্ছে করে দিলে করবে সেও কিছু পয়সা পাবে আর
item number 17,
criminal lawyer
Here for the appellant.
sorry 15
15 year for whom?
for the appellant my lord
তাহলে মানে no advocate বলছে যে ভুল বলে গেল। What
this is
does
from the legal aid
oh legal aid?
have been appointed by the legal aid services
Mr. Bhattacharya, just 1 minute, 1 minute. 1 minute, please. Yes, appeal against conviction. What section? What?
but give me 5 minutes of time and I'll come back
Bojo?
brief is coming my lord give me 5 minutes of time let Mr. Bhattacharya my lord
Tomorrow,
tomorrow I'll come back
15 টা not today করে রাখো। Mr. Dey, 16 also says NA, which means no advocate, perhaps. Jail appeal.
I can appear if nobody has been engaged I can appear
Both we are making not today. 16 also kindly try to find out if somebody is appealing.
I'll talk to the legal aid committee my lord
Both 15, 16 not today.
my lord
এই 25-এর মামলা খুঁজে পাচ্ছে না তো। They can't find the can, not cran. Supply 2 copies then. The application the department cannot find. We'll make it not today. In the course of the day, please file 2 copies. আর তুমি দেখতে বলো, পাচ্ছি না বললে তো হবে না। Not today. This is that fish stall, no?
Fish stall. 18, 19, and 20 are the identical.
Item number 18.
By the similar order, all these repetitions were
Justice Amrita Sinha. Justice Amrita Sinha.
they are unauthorized occupier. They were asked to vacate the stall.
Mr. Bhattacharya is appearing in all the matters. Only 17. 17, come back tomorrow. What to do? 18?
18, 19, and 20.
18, who is for the appellant?
I am for the corporation.
Appellant is
Dismissed. 19?
19, same identical order.
Dismissed.
20 also.
Dismissed. If before we sign the order, these are mentioned, then restored. You know our practice.
My lord's practice.
But order, at least an order may be given.
The recording an order.
Thereafter, when they mention.
Item number 21.
But I appear for the appellant. If your lordship kindly take it up tomorrow, my lord.
Tomorrow?
Tomorrow, my lord. Tomorrow.
On the request made by learned advocate for the appellant, let this matter stand adjourned for the day.
Great.
21.
Item number 22.
I am for the appellant petition. I am for the respondent number 1 and 2, my lord. I am late by Mr. Subishan. Well, let me indicate what is the matter about. The appellant was a.
But you have been protected by Justice Chando, saying that the bills raised will not be given effect to till that grievance.
He has no jurisdiction. My whole case is grievance redressal officer cannot adjudicate these disputes. So court cannot confer jurisdiction.
That's right.
Lordship. That's my ground.
Who can decide? These are factual issues. Who can decide?
Court can decide, my
lord. My lord, it's my respectful submission. Ombudsman can.
Ombudsman
can. My respectful submission, and I leave it to your lordship. But if they dissatisfied the order passed by grievance,
immediately. So why neither GRO nor ombudsman can decide? What is the matter? Let me indicate.
Chaudhary, you are fully ready in the matter? You are fully ready, or Mr. Sharnal is available today? We don't want piecemeal hearing. This appeal is directed against a judgment and order dated September 22, 2025, passed by a learned judge of this court in WPA 20955 of 2025, being a writ petition filed by the appellants herein. Stop.
The Sharnal is there, my.
Then he is here, Charu. Let us hear the matter.
May I file the affidavit of service?
I file now.
So, my lord, short, what is the matter about is
pending.
বলতে হবে তো জোরে, ওদের কপি নিতে হবে, নাহলে ওদের কাছ থেকে
ব্যাপার বলে তো কিছু খুঁজে পাচ্ছ না তোমরা?
ডিপার্টমেন্টে ফাইল হয়েছে।
Second copy.
How many copies has your advocate on record filed?
Copy file করেছিল। Copy file একটা কপি আমরা পেয়েছি।
Extra copy আছে?
Copy দেয়নি।
Second copy missing?
হ্যাঁ,
second copy দিয়ে দাও। Memo of appeal? না, stay petition, দুটোই।
Can.
শুধু application.
Stay application.
Application. হ্যাঁ, তিনটে বলো।
Can এর প্রেয়ারটা
সে আবার কি?
কি দুটো ভলিউম? I have only one volume.
Department to take for it.
Please ask your advocate on record to go to the department and sort this out. মানে ওটো ফেলে ঢুকে যাচ্ছে। We are sure it is now in some other file. Is can one, in every matter there is a can one. Is numbering is.
I mean, why cannot give a continuous serial number?
That was the case before.
Before, yes. And they get mingled up, man.
কি বলছো?
হ্যাঁ, why serial number should be there.
Not today করছি, তোমরা দেখো দেখো ওরকম অত লাইটলি নিলে হবে না। Sorry, come back to one. Mr. Shandal, the only point, Mr. Shorkar, what he is saying is that the grievance redressal cell or whatever it is doesn't have jurisdiction.
I will answer. He has the jurisdiction. I think that is the first ground in the memo.
যদি নাও থাকে
Item number 23.
I am appearing for the writ petitioner as on number
Mr.
1.
Joydeep Kaur
Yes.
tried to impress upon us the urgency. Yes. Do not start and ask for time then. Midway, we will not grant you time.
I've been asked to Lordship, can you pass over my lord only for please on this way. Because there is some urgency, my lord.
আমাকে যা কি তুমি
এই order
তারাও করুন আস্তে আস্তে। একটা ফাইল খুলে দেবে, আবার একটা ফাইল খুলে দেবে, কোনো তারাও কত 20 অর্ডার আছে। বলে এমন কাজ করে আস্তে আস্তে করলে
একটা খুঁজবে
কত
লজিক্যাল Yes, tell us what is wrong with the order. We have gone through the order.
Lordship, please kindly come to the Twitter.
এটা এফিডেভিট
Kindly come to the 14th of the impugned order, my lord.
Internal page. Mr. Kaur has come.
The existing tenderers, my lord. The work order was issued in
Did you comply with clause 39 of the tender?
Yes, we did.
On that point, the learned judge has.
Wait, let me show to your lordship that we have complied on that clause.
Yes.
That is the short point, Lord,
Short point.
of this. Now, Lord, if your lordship, Lord, kindly take the tender document and come to page 45. Start from page 45. Lord, there are two paginations. Kindly take the top one.
And achha, top one.
Because, Lord, the writ petition pagination has also resurfaced.
Mode of calculation of rates.
Yes. Kindly, Lord, come to clause 26 first, which says, which gives the diet schedule.
26 is at
Lord,
45.
page 45.
Yes.
There are two numbers, 45 and 31. Lord, if your lordship kindly takes clause 26.
Yes.
These are the diet schedules, morning tea, breakfast, etc. It relates to ESI hospital. Has your lordship seen that? Then furnishing of rates. Kindly, my lord, come to that. Kindly take B, cooking gas. I'm restricting to the dispute only. Cooking gas. The cost of cooking gas will have to be shown separately for tea, breakfast, lunch, dinner for each category of diet. Has your lordship found that? Very good. Now, my lord, please come to clause 32, which is at page 46. Clause 32.
Yes.
Rates should be quoted clearly in both figures and words in specific unit. In the interest of supply of quality diet for the indoor patients, the offered rate for raw materials should not be less than the rate calculated by the office on the basis of the rate provided by West Bengal Agricultural Marketing Board. So that's not the bare minimum that one can quote. One can't go beyond below that. And fill up third, fourth, and fifth column at financial bid is mandatory. Now, your lordships may kindly come to clause 39, page 48. The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of diet. In case of tie, the lots will be drawn under the supervision of the superintendent of the hospital with the help of the tender selection committee. Now, Lord, this is clause 39.
Tie is also contemplated in clause 32, subclause C.
Yes, yes. Subclause C, yes. In case of tie, this is actually reproduced, Lord, in clause 39 also. Then, Lord, last clause is clause 42. If your lordships kindly, Lord, turn the page. This is, Lord, a column. Average monthly consumption of diet of ESI hospital, Maniktola. This is, Lord, the data they have furnished. And then 44, fill up annexure A and B is at mandatory. Now, Lord, the dispute is with regard to clause 3942, whether 3942 was complied with by my client, and Lord, whether the tendering authority had given any concession in deviation to the tender clauses. This is, Lord, the short point. Now, Lord, please come to the quoted rate part. Please come to page 417. That your lordships will find in volume 3. 417 volume 3 though. This is our rate that we had quoted. Lord, has your lordship got Lord 417? This has two numbers, 403 and 417. 417 is at the top. This is Lord Ghosh and Ray, the appellant. At the bottom, your lordships will find the seal.
Oceanry.
Now, my lord, kindly come to the column which consists of cost of cooking gas. Has your lordship found that? Now, for morning tea, it's given 1.23. Now, for breakfast, it's also given 1.23.
1.3.
And
what is the unit? 1.23 means unit 1.23 of
1.23 is the cost of the cooking gas which is taken. Total cost per day is 6.15. At the bottom, your lordships will find. Has your lordship found that?
These are in rupees.
Rupees.
Yes. But the judgment says that you have not separately mentioned the cost of cooking.
I'll just not explain.
No, does it say so?
It does. It does. And Lord, that is where I join issue. I say that if all the offers are compared, I'll show the others offer. I'll just immediately show the rate petitioner's offer and Lord, the other offers. Your lordships will find each offer had quoted the cost of cooking gas. There is a breakup given in the offer. Now, what was the contention of the writ petitioner? If your lordships will not kindly come to page 361. Same volume. Now, my lord, this is the writ petitioner's offer. At the bottom, your lordships will find for A1 enterprise. 361. There are two paginations, my lord, 361 and 347. Now, your lordships will kindly take the column for cost of cooking gas. My lord will find that instead of quoting a flat rate, this contractor, he has quoted a variable rate, but total is 6 rupees 15 paise.
Yes.
So, my lord, on the cost, both of us have quoted the same price. But in the breakup, he has charged 22 paisa for the tea. This is cost of spending on cooking gas. So he says he spends 22 paisa for that, then 38 paisa for the next breakfast, 2 rupees 75 paise for lunch, 22 paise for evening tea, and 2 rupees 58 paise for dinner. So he gives a breakup saying that I incur 6 rupees 15 paisa. But this is on a slab, 22 paisa, so and so forth. So far as I am concerned, I had quoted 1 rupee 23 flat. I had charged 1 rupee 23 flat, but at the end,
that is a little strange. For morning tea, 1 rupee 23 paisa. For lunch also 1 rupee 23 paisa. Somewhere indicates non-application of mine.
No, my lord, I'll just let me show.
We are just thinking aloud. We are just
no, of course. Lord, the issue is I have to absorb my cost. How I absorb the cost, that I have to give a breakup. The authority can't give a breakup for that. How I run my business, I have to be aware of that. Then I give an offer. My offer is not higher than the offer of the any other bidder. In fact, there was a tie between 10 bidders.
But the point I just now indicated is not the point that the learned judge has taken.
No, Lord, because the clause itself does not say that I have to break up the cost, bringing it exactly to the extent of my cost. Actual cost. To the extent of my actual cost. That's not the clause. If your lordships goes back to any of these clauses, your lordships will find, let us not, I just show the offer of the any one of the other, and then Lord, we go back to the clause once again. Lord, kindly Lord, come to page 425. This is an offer by Sonar Bangla.
That's also flat.
Flat. In fact, your lordships will find that he was one of the persons who came within time. So, my lord, this is not, my lord, the reading of the clause by any of the tenderers or the tendering issuing authority. This is a genuine, Lord, thought process of an unsuccessful tenderer who has come to court to invoke the writ jurisdiction, and the learned judge has read the clause in the manner that he wants to read, not the manner in which the employer has read it or any other tenderer has read it. Now, my lord, let us come back to clause, my lord, 26, page 45 once again. And Lord, let us see the clauses, whether, my lord, it stipulates that it has to be to the extent of the actual cost of the cooking gas, the cost of the cooking gas. Please come to page 45. Furnishing of rates. Lord, I'm reading, Lord, clause 26, bottom. Cost of raw materials have been acquired as per West Bengal Agriculture Marketing Board. Cooking gas. The cost of cooking gas will have to be shown separately for tea, breakfast, lunch, and dinner for each category of diet. This is the requirement of the terms of the tender. Where have I violated the terms of the tender?
I was under the impression, reading the judgment, that you have not indicated at all.
Correct. That is, Lord, the finding of the learned judge. I'll immediately draw your lordship's attention to. But Lord, the requirement is that cost of cooking gas will have to be shown separately for tea, breakfast, lunch, and dinner for each category of diet.
Total 6.15 type the draw of lots that get he was corrected this interruption. Yes.
Now, if your lordship kindly goes back to clause 39 once, I'm sorry, my lord, just if your lordship looks at clause 39. Which says mode of calculation of rates. The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of diet. Overall monthly implication, monthly financial implication for supply of all categories of diet. So, Lord, one is looking at the daily rate to convert it into monthly, Lord, rate, to find out what is the monthly implication, overall monthly financial implication. So, my lord, when one looks at the rate, what is the total cost per day, and then multiply it by 30. And that is how, my lord, they found that 10 bidders have quoted the same price.
The authority will be concerned with what the financial burden on the authority will be.
Absolutely.
Therefore, the L1 gets the
correct.
10.
And Lord, out of 10 tie, there is a lottery. That is how, Lord, they have chosen. And I became L1. In the lottery, I have been allotted the work order. Work order was issued to me, Lord, in May 2024. Now, Lord, kindly look at the impugned judgment once. What are the grounds of interference? Your Lordships may kindly take the impugned judgment. Lord, I'll just take your Lordships through the operative part. Kindly come to paragraph 38.
তোমাদের এই সিস্টেমটা আমি কোনোদিন বুঝলাম না, দড়ি দিয়ে সব বেঁধে ফেলা, হ্যান্ডেল করা ইম্পসিবল। এটা খোলো, মেমোটা খোলো। তো অন্য সিস্টেম হতে পারে, তুমি
Page 19 of the impugned judgment. That's the finding. The learned judge holds from the rates quoted by the private respondent number 6, that's my client, as appearing at page 403 to 40.
That's what I told you, reading the judgment. The first thing I told you, I have not shown separately.
Lord, with deepest of respect, Lord, the petitioner wanted, I tell your Lordship, that is been the argument of the petitioner, that it must be relatable to the cost which is being expended. But that is not what the tender condition, Lord, wants. Entire argument is that there should be a slab. One can't go in for a flat rate. Lord, if I charge a flat rate and that rate is higher than the...
If it was not acceptable to the tender issuing authority...
That's the end of the matter.
Mr. Mujumdar, we are making these observations for you to respond.
Now, Lord, if your Lordships look at the chart, where, Lord, they declare the tie, which is at page 477. Lord, your Lordships will find the names, Lord, at the top. A1 Enterprise is the writ petition. I'm sorry, 477. Annexure R3. Lord, your Lordships will find all these 10 bidders, they had quoted the same price. So, Lord, monthly financial implications were same in respect of all the 10. Your Lordships will find A1 Enterprise. Has your Lordship found that? The first name at the top. The rate quoted is 128, diet 1. Lord, I just take any one diet, that will do. A1 Enterprise, Grand Supply, Nihar Enterprise, Ghosh and Roy, that's the appellant. Then, Lord, the others.
Easily, Mr. Mujumdar's client was the best. A1.
A1, yes. Lord, if we go by name, no argument. No argument. Now, Lord, kindly see at the bottom, it says, since after carrying out the exercise as per clause 39, has your Lordship found that?
Yes.
Of the tender terms and conditions on the basis of the diets as indicated in clause 42, the monthly expenses as against each of the bidder is found to be same. Thus, the tendering authority decides to select the successful bidder by draw of lots.
Yes.
Now, Lord, on the premise, if we just come back to the order for 1 minute, on the premise that...
One second. When this chart was prepared, this is dated 24th of May.
Yes.
2024.
Yes.
Everybody, all these tenderers must have been aware.
Yes.
At that stage, did anybody object that no, because of this flat rate, your client should not be considered, nobody of
Lord, it is only after the lots are drawn and that my client was successful that the present writ petition was filed. I believe they had made a representation, but Lord, they had participated in the lots. They did. Now, Lord, these are the broad facts. Please come back to the judgment based on the finding that the cost of cooking gas has not been shown by my client separately. What are the directions which are given? Your Lordship may kindly hear. Lordship has seen paragraph 38. Paragraph 40, the judgments are not considered on the ground. If your Lordship kindly sees paragraph 40.
distinguishable.
Yes, they say, it is said that these precedents are no avail to the private respondent number 6 in the facts of the present case. And then the ordering portion, therefore, based on the discussions and reasons set out in the proceedings paragraph, the writ petition is disposed of with a direction upon tendering authority to treat the bid uploaded by the private respondent number 6 is as invalid. Now, Lord, what about Sonar Bangla, who is quoted exactly the same? There may be other 3, 4. The respondent authority is further directed to evaluate the bids of the remaining bidders whose technical bids were found to be valid prior to conducting the lot in which the private respondent number 6 was selected as the successful bidder, and to finalize the tender process strictly in terms of the order dated 22nd May 2024, WPA number such and such in accordance with clause 39 and the other relevant provisions of the tender document as well as the governing financial rules within 4 weeks from the date of receipt. Now, my Lord, kindly have a look at this order dated 22nd May 2024. What?
The operative portion has been quoted in this order.
In this order. It is, the order is at page 330. Lord, whole issue is there, the court said.
Page 330.
330, the whole order is there. Page 330. ওটা কোন ভলিউমে আছে বলতো?
Volume 3.
But I am obliged to. Lord, please come to paragraph 2. At the financial evaluation stage, since there was a tie before going into the draw of lots, the tender inviting authorities are required to comply with clause 39.
Paragraph?
Paragraph 2, page 330. Your Lordship is looking at. This is an order dated 22nd May 2024. Yes. Please come to paragraph 2. That apart, at the financial evaluation stage, since there was a tie, before going into a draw of lots, the tender inviting authorities are required to comply with clause 39 of the tender document, which mandates that the calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of dye. Now, at counsel appearing for the respondent number 10 contends that the petitioner number 2's brother is at present doing the work contemplated. Kindly, my Lord, ignore this. Kindly come to paragraph 6. Learned counsel appearing for the tender issuing authority contends that pursuant to the order of this court, the tender process has mandatorily to be concluded at an early date. Hence, the representations of the petitioners are not only premature, but they would stall the tender process unnecessarily. Upon considering the contents of the parties, it appears that the petitioners' apprehension are premature, since the tendering inviting authorities are yet to take a final call on the financial bids, which have been merely opened, but no decision has been arrived at. It is expected that tender issuing authorities shall comply with not only clause 39 of the tender document, but also other relevant terms of the tender, as well as the governing financial rules, while taking a final decision in the tender process. Now, my Lord, just pausing here for a moment. If your Lordship looks at the impugned judgment, it is not the finding of the court that clause 39 has not been complied with. The court proceeds on the basis that the separate rates have not been quoted. Paragraph 36. 38. That is
39.
30, sorry, 30, 39. It's just the effect of the age, I think. But so, Lord, coming back to the 38, Lord, that's paragraph 38.
30, paragraph of the judgment.
Judgment. Paragraph 38 of the judgment. It's not the finding that clause 39. Court proceeds on the basis that I have not quoted a separate price. Judgment গুলোতে আগে ওইটা দেখাই 2022 টা আগে দেখাই হ্যাঁ 16 টা আগে
Yes.
Now, my lord, on these are, Lord, the basic facts. There has been several rounds of litigations. I am not troubling your lordships with that. That was the last order that I have shown. There has been earlier round of litigations where, Lord, originally the initial offer, the technical offers was rejected because it was addressed to a wrong person. Then that matter came to court. Court said, no, you have to accept the technical bid, consider the technical bid. There has been several litigations on this from the starting, and ultimately this is the order that it should be finalized in terms of clause 39. Lord, so far as my clients are concerned, my humble submission is there has been no aberrations of clause 39. It has been followed to the hilt. It's the monthly expenses that has to be considered for the purpose, and there was a tie. There were 10 Lord contenders, and some of them had quoted in the same manner as I had quoted. Only
I'm not expressing any suspicion, but isn't that very strange?
Very strange.
All 10.
Very strange. But Lord, I tell your lordship, so far as the pricing is concerned, the minimum pricing is given, that agricultural marketing rate. So, my lord, anybody who's quoting above that rate or below that rate is not permissible. Above that rate, his tender is bound to be cancelled. The only variable factor is the cooking gas and service charge. So, my lord, cooking gas, whatever the expected cost is, that one will do, and service charge.
All 10 offers were same.
The same, and the authorities felt that since there is a tie, then
and the tender clause permits
that. And nothing has been done which was not permissible by the
This writ petition was filed after the work order was issued in your favor, or after you were declared to be?
Just after the work order. Work order is date petition. Work order was issued on 28th of May 2024.
Where is it? Where is it?
Well, this is page 442. Page 442, your lordships will find in volume 3. The date your lordships will get at page 443. That's memo number and date is there. And the writ petition was affirmed. কবে affirmed হয়েছে? I'll just check. The date there.
Page 13.
Kindly come to page 39, sometimes in June 2024. Now, my lord, on the issue of reading of tender conditions and how far judicial review lies, and to what extent judicial review can be done in respect of the reading of the tender condition by the authorities. The first, Lord, I cite a judgment which is reported in 2022, volume 16, SCC, page 633. Lord, kindly come to paragraph 21. The facts, your lordship.
One second, Mr. Pawan.
Facts from paragraph 11, and then come to have been well settled, stated in many decisions of this court, beginning with the celebrated Tata Cellular, in which a three-judge bench of this court laid down the following principles. The principle deducible from the above are: the modern trend points to judicial restraint in administrative action. Court does not sit as a court of appeal, but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may be fallible. The terms of the invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of a contract. Normally speaking, the decision to accept the tender or award the contract is reached by process of negotiations through several tiers. More often than not, such decisions are made qualitatively by experts. The government must have freedom of contract. In other words, a fair play in the joints is a necessary concomitant for an administrative body functioning in the administrative sphere or quasi-administrative sphere. However, the decision must not only be tested by application of Wednesbury principles of reasonableness, including its other factors pointed out above, but must be free from arbitrariness, not affected by bias or actuated by malafidis. Quashing of decisions may impose heavy administrative burden on the administration and lead to increased and unbudgeted expenditure. Likewise, then what the Jagdish Mondal is quoted, judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance. If the decision relating to award of contract is bona fide and is in public interest, court will not, in exercise of power of judicial review, interfere, even if a procedural aberration or error in assessment or prejudice to a tender is made out. The power of judicial review will not be permitted to be invoked or to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interferences, either interim or final, may hold up public works for years or delay relief and succor to thousands of millions and may increase the project cost manifold. Therefore, a court, before interfering in tender or contractual matters in exercising power of judicial review, should pose to itself the following questions: whether the process of adopted or decision made by the authority is mala fide or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision is such that no responsible authority acting reasonably and in accordance with relevant law could have reached, whether public interest is affected. If the answers are in the negative, there should be no interference under Article 226. Cases involving blacklisting or imposition of penal consequences of tenderer, contractor, or distribution of state largesse, allotment of size, etc., stand on a different footing. Then, Lord, central coalfield is quoted, and your lordships may kindly take paragraph 24 once, where abscon is quoted. Kindly come to paragraph 15, quoted portion. We may add that the owner or the employer of a project having authored the tender document is the best person to understand and appreciate its requirement and interpret its documents. The Constitutional Court must defer to its understanding and appreciation of the tender documents unless there is mala fide or perversity in the understanding or appreciation or in the application of the terms of the tender condition. It is possible that the owner or employer of a project may give an interpretation to the tender document that is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given. (22.6) Lord, this is Lord supply of diet. This is definitely Lord high public interest issue. And Lord, the on assessment 10 bidders have been found as there is a tie. The price is the same. So Lord, the process which is required to be adopted under the contract has been adopted. And Lord, I am chosen. I have been given a work order. And the contract is running contract. Now, Lord, the learned judge, Lord, says that I have not quoted my price. Even if there was a possible, Lord, second view, could that view be implemented? And none of these tests, Lord, that is laid down in the judgment, the lordships will find to have been applied. On the contrary, the learned judge says none of this is applicable. And Lord, the other judgment really, Lord, reiterates this, but Lord, I just
give us the citation only. And
this is 2022, volume 6, Supreme Court cases, page 127.
Just indicate the para numbers.
12 to 16, para 12 to 16, and Lord, para 23.
23.
Kindly, Lord, see para 23 once, just Lord, placitum G, para 23. 2022, volume 6, SCC 127. Lord, kindly see placitum D, C, G. It says the approach of the court, has your lordship found that?
There is no placitum here.
Around the middle, about 6-7 lines from the top. The sentence starting with the word, the approach of the court. Has your lordship found that?
Yes.
The approach of the court should be not to find fault with magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds that there is a total arbitrariness or that tender has been granted in mala fide manner, still the court should refrain from interfering with the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than injunct the execution of the contract. So, Lord, on a broad principle, unless one finds that there is a blatant violation of the clause or some favor is being shown to a party, or Lord, it is a tailor-made contract, there is no scope for interference. And especially when Lord, the employer has given its meaning, has interpreted the clause and has given its meaning.
Mr. Mujumdar.
Well, Mr. Cord, appearing for the appellant, has referred to the bid submitted by A1, that is my client, which is one of the bid for general diet at page 361, and the bid submitted by Ghoshan Ray at 417, and the bid submitted by Sonar Bangla at 425. Well, kindly take page 369 for once. I'll come to the other issues later on. This is, my lord, the bid submitted, because the submission was made that there is no bar on the bidder to quote a notional cost. If I correctly understood the term notional cost. Kindly take 369. These are bids submitted by one CM Enterprise. My lord has got that?
Yes.
Your lordship will find again variable cost of cooking gas has been quoted.
Yes.
Now, my lord, kindly come to 377. This is the bid submitted by Jana Enterprise. Jana to eta. Jana Enterprise. Your lordship will find again variable cost for cooking gas given. My lord has got that?
377.
377, yes.
Yes.
Now, my lord, kindly take page 393, 385. This is submitted by Grand Supply. It is the allegation of the appellant that Grand Supply and the appellant are related parties. Likewise, my submission is that this petitioner, the appellant before your lordship, is a related party if and when compared to Sonar Bangla. That cannot be denied by anybody. So, my lord, now kindly take 385, Grand Supply. Your lordship will find variable rates are quoted, but the rates quoted for cooking gas, cost of cooking gas, does not match with the rate quoted by the respondent number 1 before your lordship. Variable rates quoted. Now, my lord, kindly take Nihar. My lord has got that. I'm sorry, my lord. I should have waited. I'm so sorry, my lord.
Where is Nihar?
Nihar is at 393. Your lordship will once again find that variable rates quoted.
Yes.
Then, my lord, kindly take Bhranti Bhushan Singho at page 401. Again, variable rates quoted. Then, my lord, kindly take Geeta Rani, Jana, at page 409.
Yes.
Again, my lord. Now, my lord, kindly take Sonar Bangla, my lord, Mr. Kor has cited 417. 417 is my quotation, which Mr. Kor had. Ghoshan Roy, I'm sorry, 417 is Ghoshan Roy. It is, my lord, the appellant's quotation, where your lordship will find a flat rate method has been applied.
So my lord, now kindly take along with that 425 Sonar Bangla, which again a flat rate method has been applied. So there are two tenderers who had applied flat rate method, and rest of all the tenderers applied, my lord, variable rates so far as the cost of cooking gas is concerned, and the last one being universal.
Yes.
At page 433. If your lordship kindly takes page 433. My lord has got that. So, my lord, the bidders, the majority of the bidders understood, my lord, clause 26 along with clause 5. I will place clause 5 also.
Yes.
So far as the cost of cooking gas is concerned, would be a cost which is relatable, which must have some correlation to the meal in question.
Yes.
And whenever these kind of variables are placed in the bid document submitted by the relevant bidders, my lord, then obviously, my lord, if there is a tie, this would certainly have a great impact. My lord, another variable which I made submissions before the learned single judge, my lord, as fell from my lord, that for morning tea, my lord, kindly take, there are 5 meals: morning tea, breakfast, lunch, evening tea, dinner. My lord, we have to consider, my lord, there may be 1,000 patients walking in and walking out of an hospital during a given day. Somebody may have breakfast on a given day and may be discharged, may not have lunch. There may be an intake of patients after post lunch. There may be an intake of patients post evening tea. So, my lord, this variable could only be ascertained having regard to the actual consumption on a given day. Actual consumption on a given day. So, my lord, there the question would arise when this kind of assessment is made. The assessment cannot be based on notional cost. We are talking about state finances. Ultimately, the money flows out of the state exchequer. Every endeavor should be made by the tendering authority to ensure a cost-effective solution for the department in one hand, the state in one hand, and also not compromising with the quality of meals. Now, how the quality of meals are not compromised, they say, my lord, your lordship had put a very interesting question. I'm sorry, my lord.
Yes.
I'm sorry, my lord. How, my lord, how all the bidders submit the same kind of bid? My lord, this is a very important question. My lord, there are 2 constants. One constant is that, my lord, the cost of raw materials, which can never exceed the rates specified by the Agricultural Marketing Board. There is another constant, namely the total cost of cooking gas being ₹6, 15 paisa, which your lordship will find at clause 5 of the tender condition. Kindly take clause 5 of the tender condition. Subject to correction, perhaps Mr. Kaur did not place that clause. Subject to correction, and I will stand corrected, obviously. Kindly take clause 5, which your lordship will find at page 43. If your lordship takes, my lord, 5 III and III, in the interest of supplying quality diet for indoor patients, the offered rate for raw materials should not be less than the rate calculated by the office on the basis of rate provided by the West Bengal Agricultural Marketing Board. So, my lord, if the rate of potato fixed by Agricultural Market Board is ₹5, they cannot quote a rate taking into consideration rate of potato at 3. For example, that's an example I'm giving. Similarly, so my lord, one constant is the bare minimum, another constant is the maximum. So far as my lord, the materials are concerned, the minimum has to be maintained. That is the rate specified by the board. And so far as the cooking gas is concerned, my lord, maximum it would be ₹6.15. My lord, this is a fiercely competitive bids. So none of the bidders, it has become an usual practice. And my lord, Mr. Bandyopadhyay, who regularly appears,
Yes.
but since these are fiercely competitive bids, Mr. Bandyopadhyay would agree that none of the bidders make any additional quote for service charge which they are otherwise entitled to under the bid. So, my lord, we left with two constants. When we, my lord, put in the data, following the two constants, the bids are bound to be identical. So far as the total price is concerned for a given day. Now, it is not my case before your lordship that, my lord, my learned friend's client did not follow clause 39. It is my case before your lordship that state did not follow clause 39. While assessing the, kindly take now clause 5. Clause 5 your lordship has taken. Now kindly take clause 26. Clause 26 your lordship will again find furnishing of rates. The five categories of meals are there. Now furnishing of rates, cost of raw materials have been acquired as per the Agricultural Marketing Board. Cooking gas will have to be shown separately for tea, breakfast, lunch, dinner for each category of diet. But much emphasis has been supplied to the expression used by the learned judge regarding shown separately, that I have shown separately. But my lord, the judgment has to be read as a whole. Paragraph 36 of the judgment, if your lordship now kindly takes, the impugned judgment. Just 1 minute, I'm sorry, my lord. Kindly take, my lord, the impugned judgment. Kindly take, my lord, paragraph 36. My lord, the decision, analysis and conclusion starts from para 32. My lord, the learned judge at para 34 quotes clause 5. I'm sorry, my lord. This is 5. My lordship is looking at the memorandum of appeal. Very well, my lord. The internal page, I'm just kindly take, my lord, the internal page 11.
Yes.
May I read out, my lord? Para 32 onwards. In pursuing so and so, pursuing socio-economic objective, state is obliged to invite tenders or hold public auctions and engage so and so. This is all there. Now, my lord, what is interesting, kindly take the last sentence of para 32. At the same time, the state, while entering into a contract with a private individual, is expected to adhere strictly to the terms and conditions of the contract and in tender matters to the terms of the tender documents. In the instant case, based on the pleadings and arguments of the rival parties, it is quite vivid that the question that arises for determination is whether the tendering authority, by completely disregarding essential clauses of the NIT, including what clauses 26, 39 and 42, as well as the orders of this court, acted unlawfully in finalizing the tender process through draw of lots and in awarding the contract and or issuing work order in favor of respondent number 6. My lord has got that. So, my lord, this was the issue framed by the learned single judge. Then, my lord, clause 5 is quoted, clause 26 is quoted, and then, my lord, obviously, clause 39 is also quoted. Clause 39, I will come to it later. Kindly take, my lord, after 39, 42 is also quoted, because, my lord, kindly take, this was the submission made on behalf of the, my lord, the appellant before lordship in the writ court, that look, these are the number of patients, 6356. 6356 may be the total number of patients in a given month. But one has to understand whether this 6356 was a constant number on a given day. Well, that is how the computation is to be made. Now, my lord, kindly take, in the present case, it was asked that the tendering authority proceeded in contravention of the order dated so and so and match so and also, my lord, 22 order dated 22/5/2024 in WPA number 13777 of 2024. So, my lord, then, my lord, the orders are quoted. The operative part of the order passed in WPA number 13777, your lordship will find at page 17 of the judgment, internal page 17. Now, my lord, kindly come then to paragraph 36. This is the most important paragraph, because, my lord, your lordship, I would beseech your lordship that your lordship would kindly read paragraph 36 along with 38, 37 and 38. Therefore, in terms of the order dated 22/5/2024 passed in WPA number 13777, the tendering authority was required to comply with clause 39 and other relevant provisions of the tender document, as well as the applicable financial rules, because rule 177 provides that, my lord, the best price is to be obtained or the lowest bid is to be accepted. But it is very easy that you get, my lord, identical bids, hold a lottery and get the man. But, my lord, the process is not so easy. First, a complex process has to be undertaken, that even in taking into account the average monthly consumption, having regard to, my lord, take average monthly consumption, how it is to be determined. Suppose, my lord, the bid is held in the month of February. Then, my lord, average monthly consumption, they may take the last preceding month before.
Yes.
Now, my lord, kindly take, my lord, clause 36. Therefore, in terms of the order dated so and so, then, my lord, 37, in accordance with clause 26, each bidder was required to indicate separately the cost of cooking gas and service charges. The clause further stipulates that if a bidder fails to quote the rates properly, the bid shall be liable to cancellation. Then comes clause paragraph 38. From the rates quoted by the private respondent, number 6, as appearing at pages 403 to 410 of the writ petition, it is evident that the cost of cooking gas has not been shown separately. My lord, this is the bone of contention, that when this is a wrong finding. My lord, my case before lordship is that, and it was my argument all along before the honorable single judge, that look at the rates, take the average monthly consumption, and if the variable rates of cost of cooking gas is given, then the results would be obviously variable. And also, there is another variable factor, that is the number of patients who are taking different meals on a given day. And this exact process was followed in, my lord, this bundle, which comes under the same directorate of ESI. A detailed process was undertaken, and I produced all those materials before the honorable single judge. My lord, the conclusion, your lordship's conclusions are correct so far as clause 39 is concerned. Conclusion, in my most respectful, my lord, your lordship will rise. Man, we'll come back.
Come back.
So what is coming, my lord? May I just oh, may I just, my lord, indicate what Mr. Majumdar is saying, or your lord, he has come.
Yes, yes, relax, relax, relax. Do you wish to rely on any authorities?
But I would be first, my lord, I take your lordship to my lord. I was reading paragraph 38, 38. My lord, my understanding is that having regard to my lord, the reasons cited in the judgment, these reasons, so far as shown separately is concerned, shown separately would mean, my lord, commensurate to the meal in question.
You said so. It must have a.
Now, my lord, kindly take one document which is there, which was there before the read code and also before your lordship in the part of in the stay application itself. Kindly take, my lord, page 345. Same directorate. My lord, there are 3 SI hospitals, namely Bandel, Shialda and Maniktola. In Bandel and Shialda, this clause 39 had been invoked. Kindly take Bandel, which is at page 345. Here, A1 Enterprise, that is my client, did not emerge as the successful bidder. Now, my lord, kindly take, my lord, straight away 348. Rates were again identical. Your lordship has got that.
345. What do you want to say?
My lord, this is the my lord the tender summary report. Bandel. Your lordship will get Bandel.
Yes,
This is
we've
for
seen
Bandel,
that.
Labor Department Bandel, tender summary report. Now, my lord, kindly take the page 348. That is, my lord, BOQ summary details for Bandel. Your lordship will find again, well, as I pointed out to your lordship, identical rates are quoted everywhere in all these tenders. Then, my lord, kindly come to page 349. This is a comparative statement as per individual BOQ. Then, my lord, kindly come to page 350. This is the pointer. This is how it should be done. And it was done in Bandel, it was done in Shialda. Average monthly consumption of diet bill of Bordhon Enterprise. This is one. This is a successful bidder, right? Successful bidder in that case. My lord, kindly take general diet. Your lordship need not look at any other diet. Your lordship will find the number of patients are again variable for different diets. Your lordship has got that? It has to be, my lord. Then, my lord, the quoted rates are applied. Then, my lord, the amount is arrived at. And then the subtotal is worked out. This exercise has not been undertaken in this case, despite representation made by the petitioner as long back on 13th of May 2023, 1 year ago, before the entire tender process was completed, and also on the date, another representative, when this, my lord, this bid summary report was published, on the date of 28th May 2024. My lord, why we filed a writ petition on 14th of June? We could not file the writ petition on in the month of May or first week of June because the court was closed. So, lordship will find this is the page 350 is, my lord, the successful bidder Bordhon, and 351 is A1 Enterprise, that is my client. Your lordship will find again variable rates applied, but again I failed because I could not satisfy the rate.
But why you are participating in the lottery?
Sorry, my lord.
Participating in the lottery. Why
There is no process of participating in the lottery. They will hold the lottery on their own.
So why you have not
On the date when the lottery was held, I registered my protest. It's not that, my lord, I did not register my protest.
How?
By letter. That is there on record. Kindly take, my lord. I am grateful to your lordship that your lordship is has put this question to me. Kindly take, my lord, page 336. 330 na কত number page? 340. That is my letter, though. Yes. Kindly take page 340. Kindly mark the date, my lord. This is on 28th of May.
And why is this receiving sin?
Well, it has been received. My lord, there is no, my lord, they are not dispute. State is not disputing that they did not receive it. But it is very strange in this matter because two affidavits have not been disclosed in the stay application. The affidavit in opposition filed by the state and the affidavit in opposition filed by the the appellant before lordship. Now it was a private respondent before in the writ court, are identical word by word. And I can demonstrate it right now because because this is not part of the stay application. So, my lord, favoritism is writ large on the face of the records. And I will show that. And it was received on 28 May that your lordship will find at page 341. And my lord, it's not only that, my lord, there was a direction by the honorable single judge, honorable single judge.
When was the lottery held?
Lottery was held on 28th. 27th we received email. This is all there in my petition. Page 13 of my petition, page 27 your lordship may kindly take. Your lordship will get the sequence of events because I am grateful, my lord, lordship is putting these questions to me. If there were any latches on my part or not, my lord, I have to establish with your lordship. Kindly take, my lord, page, paragraph, para 34 onwards. 34 ছেড়ে দাও না এটা কোথায় পড়ছি আমরা page 27 এটা part of the writ petition para 34. Kindly give me one second. আজ আমি এখান থেকে পড়ছি kindly take para 34. Page 27. The petitioner number 2 on 20. I'm sorry, my lord.
Yes.
Petitioner number 2 on 27/5/2024 received an email from the respondent number 5 wherein the following was informed. This is to inform you that the selection of L1 bidder for supply of cooked diet for indoor patients at ESI Hospital Maniktola will be held tomorrow. That is 28 May. And on 28 May I registered my protest. The petitioners were requested to attend at the time of selection process. Then, my lord, obviously, my lord, your lordship will get the sequence. And interestingly, this particular document, this bid summary document, which is at page tender summary at page 336, this bid summary document was annexed to the affidavit of the private respondent being the appellant before your lordship. 477 and not to the affidavit of the state. So the private respondent had the occasion to get hold of this bid summary document. Kindly, my lord, take the two affidavits. The affidavit because these are all part of the record and submissions were made. It's not that I'm making these submissions first time before your lordship. Kindly take the two affidavit in opposition. One by the respondent number 5. One by respondent number 5 and another by the respondent number 6. One is state and the other is same. my lord, kindly take paragraph 4A of the AO of R5, paragraph 4A of AO of R6. Oh, 2 theki. There are 2 affidavits in opposition. DH's copy. One opposition, your lordship, is there on record in the stay application. The other opposition, page 444. The reply we will rely on later because we pointed out these facts. Kindly compare page 444 of the stay with my respondent number 5 is, my lord, the state MPO, come superintendent of ESI hospital. That is not on record. The affidavit in opposition of respondent number 6, who is the appellant before your lordship, that is on record at page 444. Now, may I beseech your lordship, if your lordship kindly keeps the 2 affidavits side by side, I will be able to demonstrate that identical averments have been made by the private respondent being the successful bidder and the state who is the employer. এটা ঠিক আছে, এটা ছেড়ে দে, এটা 2 দে, এটা 4 থেকে দেয়। In fact, paragraph 2, 3, which are standard paragraphs, they are identical. Paragraph 4A is identical. Paragraph 4B is identical. Paragraph 4C is identical. Paragraph 5I identical. Paragraph 5II identical. Paragraph 5III identical. 4 identical. 5 identical. 6 identical. 7 identical. 6, 7, 8, 9, 10. My lord, this is like, my lord, just.
This is not a point that you urged before.
Yes, I urged. I urged before the honorable single judge, and that is there in my affidavit in reply.
Yes, but that is not recorded at
That
least
is
by
may
the-
not be recorded, but my lord,
We can't take note of it unless it is recorded in the order.
my lord, your lordship may take note of the this particular fact, because my lord, this fact was brought on record by my affidavit in reply. And my lord, Mr. Bandyopadhyay is here. I made these submissions. Your lordship can assign separate reasons, different reasons to affirm the judgment. But this is a fit case where your lordship may assign different reasons to sustain this judgment, to affirm this judgment. But this is writ large on the face of records, and I made this submission. It's not that I'm making this submission for the first time.
Yes, let us slowly wind up now.
Yes, my lord.
Yes.
My lord, so my lord, so your lordship, my lord, my respectful submission before lordship is that since these are part of records, and my lord, the powers of appellate court, my lord, I need not make that submission. My lord, your lordship can assign different reasons to affirm this judgment.
Yes, I believe under order 41.
Rule 31, it is there because contents of the judgment, my lord, different reasons can be assigned. And it is a matter of fact, my lord, this is in the nature of, my lord, first appeal, where your lordship can appreciate whatever evidence was laid before the single judge. And my lord, it cannot be their case. My lord, I know Mr. Bandyopadhyay, he will never argue that I did not make this argument. And finally, my lord, the judgment cited by Mr. Kaur, relied on by Mr. Kaur. Those judgment, your lordship, there cannot be any cavil to the proposition that terms of tender document cannot be challenged. But it is not my case to impede the tender process. My case is that the tender process should have been conducted in terms of clause 39 of the bid document. So, none of the judgment, the two judgments, but the other judgment is on a different context. The first judgment, does not come to the aid of the appellant before lordship because, I have not questioned the terms of the tender document. So, and one more thing, they are operating for 1.5 years. Now, they also have their monthly figures. If their invoices are directed to be produced, that will clearly indicate that flat rate method cannot be applied. Mr. Kaur made one submission that it is a notional rate. My case before lordship for preparing a cup of tea or tea per patient, or the patient as such, then 1.23 rupees of cooking gas cannot be consumed. It is not notional, it is fictional. Only one submission. Another clause of the tender document, page 45. This will clearly indicate that the variable factor of the patients have to be taken into account. How this work is to be executed. Page 45, clause 25. Selected bidder or his authorized representative will have to collect requisition slip, indents for serving diet from authorized persons of the hospital twice a day. So, why it is necessary? Because there may be a change in the number of patients during the day. One in the morning and in the afternoon, and the diets will be served based on those requisition or indents. Besides, kindly I am skipping over 3 or 4 lines. Besides, patients admitted in the hospital up to 7 p.m. are entitled to get admission diet depending on his or her time of admission as mentioned in the diet schedule. So, this variable number of patients had to be factored in while computing the monthly average financial implication. But these are my submissions. These I am grateful, these are my respected submissions.
Mr. Bandyopadhyay, first thing, it is extremely strange. Word by word, how could your affidavits be same?
My reply is always comes first. Your lordship knows, I have served everyone. I didn't get any copy of the state's affidavit in opposition, filed before the learned single judge.
That we don't know who got it first, who got it second.
My affidavit reply.
This, I have never seen this.
But my affidavit reply has been served. Now, if states choose to use it, to prepare their affidavit in opposition,
who is appearing for the state? Nobody is appearing.
Milat Paul.
Where is he? No, we need to hear him. This is sufficient to raise eyebrows, at least.
This happened, after lottery,
not word
after
to word.
Work order.
No, forget about all those things. We are more or less acquainted with the law, how far we can interfere.
No, only one thing, to clarify, what he had submitted. Kindly take clause 5 once,
We are not on merits.
Oh, no, I'm
Only
just giving his reply,
Identical affidavits.
I have no idea. I didn't have any copy of the state's affidavit
That
in
would make
opposition.
anybody suspicious that you were the favorite child.
Then I'm giving the facts. A1 was the existing supplier. He was supplying there. His brother, grand supply, got the work order initially. He supplied for 7 days. Then his tender, our rejection was challenged. This is the 4th round of litigation.
Ask Mr. Chatterjee to be here, sir.
My lord, may I just give reply, my lord, to the
You
on
will
merit?
after we hear Mr. Chatterjee, because you need to give reply to both. Yes.
That would be.
Come back tomorrow.
Well, so far as his my lord, submission, only two clarifications. I'll not take 2 minutes, my lord. Two clarifications. Kindly come back to my lord, clause 5 of the tender, my lord. Kindly see once, my lord. Only two clarifications. Clause 5, financial bids, my lord. It says, my lord, he had read in the interest of supply query. Then 3, clause 3, he read that the cooking gas has been fixed at 615 per day. Then the clause 4, that would be the very vital. The rate offered should be consolidated. Kindly take my lord, clause 4. The rate offered per page 43 in our page 29.
Yes.
The rate offered should be consolidated. Cost of raw material, cost of cooking gas and service charge, including profit and taxes, if any. Well, now the clause 39 and the what the Bandel and Sialda they were showing, I'll show the Sialda terms and conditions and compare it with the this clause 39. Kindly take page 325. That was the Sialda tender terms and conditions.
They showed us Bandel, so you better show us Bandel.
Bandel, they didn't annex. They also tender terms are not annexed.
Annexed.
কোথায়?
আছে প্যান্ডেল annexed আছে? হ্যাঁ আছে।
Now kindly take 350 Bandel, which was BOQ given.
No, it is annexed.
Tenderটা কোথায়?
বলছি তোমাকে দাঁড়াও এক মিনিট দাও। Clause is 15 না? 15 কোন পেজে আছে বল? 356 স্বাগত। Clause 15.
Yes. But I'll come back. Kindly take BOQ 350. 350 for Bandel.
315.
350.
353.
350.
That is Bordhon Enterprise.
Yes, that is his. He was the successful. He quoted.
Yes.
Now these figures were mentioned in the tender. Here, you also will find clause 42. That is the daily consumptions. The given yearly consumptions, clause 42. But these number of patients who will be consuming breakfast, who will be consuming lunch, these have been given in that tender. And now kindly come back to 325. That is the Sialda term.
Where is that tender?
That they have annexed. I don't know whether they have annexed the entire tender document. 340.
তুমি কি ব্যান্ডেল খুঁজছো?
341 is the corrigendum.
না তুমি কি ব্যান্ডেল খুঁজছো?
হ্যাঁ 355 is corrigendum.
56.
56 is part.
ওই যে ওইটাই 59.
Part starts কোথায়?
59. আমার ক্লজটা হচ্ছে 59.
356 is part.
Part, correct. Part.
The entire tender document is not. 355 kindly take the Bandel.
The relevant condition, just to assist your lordship, relevant condition in Bandel is clause 15I, if and when compared to clause 39 of the present tender. At page 356, 15I.
This bed strength was not. This was given in the Bandel.
You have not annexed the entire tender document.
In that tender. Now, kindly just 1 minute. Kindly take Sialda. They relied on 325. This entire tender is annexed. I don't know whether it is entire tender. It is also
Banerjee, 325, they had, Mr. Mujumdar did not show us.
Yes, but this is the Sialda there he relied on. Kindly take just 40, clause 40. Kindly take clause 40. Based on 2015-16 rate. This is of 2019 tender. They are saying that it will be assessed on the basis of 15-16.
Yes.
Here, my lord, clause 42 I, as a tenderer, only get these that the who are not there. They are the existing. They may be aware what is the actual consumption. From the outsider, we get it from 42 list, plus 42 of the tender. These are the consumptions. And we have quoted separately. The only reason shown, which is not tenable in the eye of law.
When was their affidavit in opposition affirmed, and when was the state's?
My affirmation was 30th August 2024.
And respondent number 5?
The state's affidavit was affirmed on 5th, 5th August. Yes, 5th August. And ওদের affidavit তো স্বাগত
30th August.
So their state's affidavit was affirmed prior to the affidavit filed by the, but it was not
Then I copied. But then because these are the available materials. These are everything is on record. These are e-tender process. Everything was on record.
No, that's all right. The language can't be identical, Mr. Banerjee.
No, language cannot be identical. Somebody had copied.
State's affidavit,
but that doesn't dilute the
state's affidavit
the merit of the case.
Though the state's affidavit was affirmed on 5th August, it was served much later.
10 bidders, lottery conducted, they were successful. His brother was successful, he didn't challenge. He didn't challenge the tender. He didn't raise this issue that clause 39 was not complied with.
Please,
when his brother was allotted again on lottery.
Please tell Mr. Kaur, we would like to hear him, even if we are with you on merits, that the learned judge should not have interfered on the ground that he did, but you have to explain these identical affidavits of the state, and otherwise
I say
send it back to the judge, learned judge, to consider this aspect, which, as Mr. Mujumdar said, he had argued,
yes,
but has not been recorded.
I argue. There is no doubt about it.
My lord, I'm putting a question myself. Don't, my lord, even if somebody had copied, the facts remains the same. These are all on e-tender.
The fact remains, maybe the lottery was manipulated because you are the favored person.
My lord, it was them who got it earlier. It was them,
not us.
My lord, it was his brother who got it
lottery,
earlier.
Who got it in the lottery last time?
Last time I got it. The first time they got it. And I have stated the
same.
Shall we
close the hearing then? Shall we close the hearing? Or you want Mr. Kaur to address us?
Your lordship was supposed to hear the state.
Not necessary. You will have to explain.
My lord, Mr. Kaur has expressed that I can give this reply that I show clause 5 and clause 42.
Very well.
But if your lordship desires to hear it further, my lord, your lordship can give it.
No, you have not addressed us on the aspect we want you to, because perhaps you have nothing to say. Maybe the same lawyer drafted both.
Maybe.
Hearing is concluded. Judgment is reserved.
I only submit to that is not so fatal, my lord. It doesn't say, they have not alleged that the hospital has, my lord, malafidely chosen me. It was not their allegation in the entire writ petitions. I can show it from the writ petition itself.
You could get it only from the affidavits.
In the writ petitions, there is no such allegation that I was favored, I was chosen in the lottery.
They need not.
It was not allegation. So if they say that because of the identical affidavits, I was the favored, my lord, this probably doesn't stand in the mouth. Because of the sequence of events. Only may I ask for a stay because the hospital is trying to cancel my tender. There was no time period given, as Mr. Rao Chaudhary said. It said hospital should comply within 4 weeks. Now my bid had been cancelled. Now the hospital is, even yesterday they threatened to proceed.
You are for the hospital? State?
Yes, they are for state.
Do you wish to make any submission? Hearing conclude corona. State to kichu boleni ekhone. Are you appearing in the matter?
My lord, may I just make a suggestion subject to lordship's kind consent and subject to, my lord, whatever Mr. Bandyopadhyay would submit. My lord, let the process continue. Your lordship is reserving the judgment or hearing them. In the meantime, no final decision be taken till the
that order we want to record in the presence of the State Council.
Your lordship will not get, we could not get the State Council even in the writ proceeding. Mr.
No, no.
Bandyopadhyay,
Ask him
and
to be
I
here
are
tomorrow.
allied him so far as that issue is concerned.
Ask him to be here tomorrow.
Mr. Chatterjee was there, my lord, when the hearing started.
Hearing started, Mr.
He was
Chatterjee was
there.
here.
This will be tomorrow. This will be the first item.
Very well, my lord.
Marked 10:30.
Yes.
After this, we'll take up criminal matters.
Very well. Great. 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 I take your lordship. Right?
Yes. We have heard Mr. Mojumdar, learned senior counsel for the, sorry, Mr. Joydeep Kaur.
Mr.
Joydeep Kaur, learned senior counsel for the appellant, as also Mr. Mojumdar, learned senior counsel for the respondent numbers 1 and 2.
One.
Respondent number 1.
1 and 2. One to proprietorship.
Paragraph.
1 and 2.
1 and 2. 1 and 2. ঠিকই বলেছিলেন।
One is the proprietary concern, my lord. We cannot have any
paragraph. Mr. Chatterjee, learned state counsel is not available. Stop. Mr. Chatterjee is requested to be before us tomorrow when this matter will be listed again. Marked 10:30 a.m.
May I request it, my lord, to be 11:30, my lord, because another matter has been
Mr.
fixed at
Bandyopadhyay, you
10:30.
have to adjust with us because we can't adjust with everybody.
I'm sorry, my lord, but just this is my request, my lord.
It won't take more than 5 minutes because I don't think the state will have much to say. Mr. Mojumdar has argued at length. You have argued. We just want to hear Mr. Chatterjee's view, what he thinks about it.
Great. Great. So great.
Yeah.
Item number 24.
Lordship, I am for the respondent victim girl. Lordship, I am praying for a very short pass.
My lord, I am for the applicant, my lord. Hearing for whom?
Item number 20.
Yes.
Lordship, I am led by Mr. Mukherjee. He is in court 26. He just requested for a very short passover. We are for the victim girl, Lordship.
My lord, I've been waiting
Sorry.
since 10:30 and this is the third date.
Yes. You proceed.
I'm obliged, my lord. My lord, I have filed, my application is for suspension of sentence and to be released on bail. I am for the appellant, my lord, who was convicted under section
How long are you in
375.
custody? How long are you in custody?
Since 31st of January 2025. It's nearly 9 months now, my lord. More than 9 months, my lord.
When did the incident take place?
My lord, we were into a love relationship since 2018, which is there in the letter of complaint. And the letter of complaint was dated September 2021. That is after 3.5 years. I was aged 33 and the lady was aged nearly 29 years of age. I'm an ex-naval officer who took voluntary retirement from the Short Service Commission, but I am still presently in the reserve list of the Indian Defence Services.
You and the lady were neighbors.
No, my lord.
No.
We met over a dating app, Tinder app.
The lady was married.
No.
No.
I was married, but I was living separate from my wife. And with the aid of the lady's parents, I have obtained a divorce in the year 2020. This was a total consensual love relationship, and my lord. I was on bail, my lord. Yes, my lord. During the entire period of trial, I've been on bail, my lord.
My lord, I am for the victim led by Mr. Mayur Mukherjee. His own leg. The allegation of 376 or 70.
Charges were framed under 417.
417 have been acquitted, my lord.
Yes, ma'am.
That there was an allegation.
My lord.
76,
70.
That they did not disclose that
Second
he was
marriage.
or
About the second subsequent marriage.
but, she was a usual lady.
And the allegation is that she used to go to the house of the appellant, used to stay there over the weekends. But the only thing is, the second marriage was not disclosed.
He was on bail.
Yes,
my
my lord.
allegation that he misused his liberty.
To 2nd June 2018, date of offense.
Yes.
30th September 21 is the FIR.
If I was lodged.
And my lord will kindly
All
read
along
the
on
last
bail.
line.
417 acquitted.
Acquitted.
There can't be a better case for suspension.
Yes.
Yes, what do you have to say? De facto.
We are from the victim, my lord. The Mohit Mukherjee is appearing, my lord. The late by Mr.
We have heard that. We have heard that. Do you have to say anything?
My lord, the last at the time of the bail hearing at the district judge, they had mentioned the PP has submitted one document. She was pregnant on that time. Thereafter, that has aborted. So they are unable to produce that document. The court has asking for produce the document. So that document was not there. So that was still pending on that moment. Thereafter, charge sheet has been submitted and trial has been communicated. Witness has been examined. After considering the facts and circumstances, the court has concluded that the judge.
Sir, we are not acquitting him. We are only saying that given the fact that he was on bail all throughout, it is nobody's case he had misused or abused the privilege of bail or jumped any condition of bail, and also on a prima facie appraisal of what is on record, more than 3 years gap
Yes, my lord.
between the incident and the
My lord,
FIR.
after the incident, the accused person has came to her lady's house and he has abused in front of his parents, and the parents also abused. Thereafter, the GD has been lodged. The one FIR has been lodged also.
That's not, it is a available office. That is,
We are granting this one.
Lord, she refused medical, so what document he's speaking of, my lord, that is not exhibited. She refused medical. Yeah, you have stated she refused medical. So that pregnancy documents and all, that is not on records.
Not on record. We can't
Not on
take
record, so I cannot comment on
The learned counsel for the petitioner has submitted that the petitioner was all along on bail during a trial and it did not misuse the event during pendency of the case. Stop. However, as there is no chance of early hearing of the present application, may be enlarged on bail on any condition after suspending the order of sentence. Stop. Error. The learned counsel for the de facto complainant has raised strong objection. According to him, there is sufficient incriminating evidence against the second petitioner, and as such, he opposes the prayer for bail. Stop. Error. The learned counsel for the state, while opposing the prayer for bail and suspension of sentence, has submitted that has drawn the attention of this court, the one of the factual aspects of the case, the effect that the victim refused medical examination during investigation. Stop. Error. We have considered the details on record, also the judgment.
এখানে একটু বলে দিত অফেন্সার 3 বছরের পরে এফআইআর
Offenses, offense, judgment, and we found that the learned judge has recorded that victim doing a measure had consented to physical relationship on the understanding that the petitioner will marry her. Stop. It appears from the record that the offense was alleged to have been committed in the year 2018 and FIR was lodged 3 years thereafter.
More than 3 years.
More than 3 years thereafter. However, as there is no chance of an early hearing of this appeal, and further, petitioner was all along on bail, and there was no allegation that he misused the liberty granted to him. We are inclined to allow the prayer for bail on certain conditions. বলে ওটা দিয়ে দেবেন, যে যা যা লেখার Residing where?
He is running his academy in Bengaluru.
Yes.
Being a veteran naval officer, right now he is training the future generations who will be appointed in the defense.
Care of that students, I do not know what will happen to that.
So my lord will keep it as my lord will say.
Okay. So jaja condition ache aজকে থাকে. What is the local? He has to remain in the Kolkata.
We will do that, my lord.
Shall remain within the.
We will do that, my lord.
Which correctional home is he?
My lord.
Which correctional home is he in?
He is in no. He's in Alipur in the presidency jail.
Metropolitan limits of Kolkata.
But the judgment was passed by the Howrah court, my lord, the trial court at Howrah.
PS was Domjur PS, so it was a.
My lord, we will give an address of Kolkata.
Limits of
I
Kolkata.
will talk to them and we'll give an address of Kolkata.
The concerned local police station, IC of the local prosecutor, once in a month.
So we will not leave this
Will not be Kolkata
without the prior permission.
without the prior permission of the IC of the concerned local police station where shall reside. ওটা এটা ঠিকভাবে কারেক্ট করে লিখতে পারবে না তো বলতে হবে।
অন্য যেগুলো আছে সব দেবে।
And he shall be personally or
আর once a month report করবে কি?
once in a month বলে দিয়েছে।
Once a month to report?
Yes.
Satisfaction.
Satisfaction of?
CTM Howrah?
CTM Howrah. Paper book ready? Paper book is ready?
Ready.
Paper books are ready.
We had made it ready in the meantime, my lord.
Where the appeal be listed 2 weeks hence.
My lord, only not from the 28th of December to the 28th of November to the 10th of December, my lord. Anytime prior to that and after that.
Appear in the monthly list of December.
My lord. I'm much obliged, my lord.
My appearance.
Yes.
That is my main.
Your objection has been recorded. Yes.
That is.
This is a case.
Vehement objection.
I'm much obliged, my lord. Much grateful.
Deeply. We come for bail for your lordship in these matters. Bail and anticipatory bail. Part 4.
If you were a judge, you would have granted this bail.
Deeply.
Very much grateful, man.
Item number 25.
Well, I am for the appeal.
Opposing on behalf of NCB, along with my learned friend Uttam Boshak.
Twenty-five.
Nigerian.
Well, the appellant.
James Kevin Edward.
No. What was the direction that it will be listed amongst the first 5 items under the heading criminal appeal hearing? কিসে দিয়েছেন? ও সেটা bail application আছে বলে সেই জন্য।
My lord, the passport is now with them. So, my lord, there is no chance.
What are the what are the wrongs committed by the judge?
My lord,
how many wrongs he has committed? How many wrongs he has committed?
My lord, only one.
One. That's.
My lord, 170 grams of cocaine was recovered. My lord, PW1 has stated
that the search, my lord, information was received by Shantanu Dev Aich. Shantanu Dev Aich was a member of the raiding team. PW1 in his deposition stated that we gave the option to the detainee that we have a gazetted officer in our team as well. You, if you wish, you can be searched in front of him.
Writing that notice has been served.
That was served. My lord, yeah, we have a gazetted.
Your only point is Paramananda.
For Paramananda, my lord, following which this honorable court in Ishdan Sheikh has been pleased to hold that if such an option is given, that the gazetted officer is there in the team, the search gets vitiated and the conviction is liable to be set aside.
So that is different. How much cocaine?
170 grams, where 100 grams is a commercial quantity.
So whether
It was in the possession, pocket.
in pocket.
And my lord, even in Ishdan Sheikh, this honorable court has been pleased to hold. My lord, I have submitted my written notes along with the judgment.
Answer that yes, I want to be searched in presence of gazetted officer.
My lord, it was
Notice was served.
notice was served.
And what is your client's answer at that point of time?
My lord, it was accepted and said that you can search me. My lord, that was the thing.
So
That is, my lord, it is that duty on the part of the prosecution.
I'm saying that you refuse to be searched in
My lord,
presence of.
it is the duty of the prosecution to explain the rigors of the NDPS Act and the benefits that has been held by this honorable court, that what is the consequence of not being searched in presence of an independent officer or a part of the raiding team.
So only short.
Only short question. Yes. My lord, will kindly comes to PW1 first.
How is the deposition?
My lord, paper books are there. Section 15 notice exhibit 3.
Page number?
PW1. My lord, may I first come with the FIR, my lord, with the written complaint? Start with the written complaint. My lord.
And you will get only 10 minutes time.
My
Lord, kindly keep the exhibit file beside your lordship. Kindly keep this.
My lord, the written notes are there with your lordship's file. Yes. My lord, the FIR, my lord, the written complaint is at page 1. My lord, it starts from page 2. The date of seizure was 4/1/2018. That act, my lord, I am reading from paragraph 2 of page 2. That acting on specific information received on 4th January 2018 from a reliable source that a huge quantity of cocaine is going to be delivered by a Nigerian national male aged about 28 years in front of City Center 2 Action Area IID. So and so on 4/1/2018 at around 14 hours. The same information was first reduced into writing in the proforma prescribed in NCB 1 by Sri Manoj Kumar Mishra, Intelligence Officer, NCB KZU, and intimated the same to his immediate superior officer, and after obtaining necessary permissions and movement order from the competent authorities, a team of NCB officers and staff led by Sri Shantanu Aich, Superintendent, NCB KZU, Kolkata, left the NCB office premises in Newtown, Kolkata at about 12 hours on 4/1/2018 and reached City Center 2 Action Area IID, Newtown, Kolkata, WB at around 12:30 hours on the same day. Thereafter, the NCB team approached two persons standing there and informed them of the input available with the NCB officers that one Nigerian national male aged about 28 years is said to deliver cocaine in front of City Center 2 Action Area IID, Newtown, Kolkata, WB 136 at around 14 hours on the same day. The NCB team further requested them to act as independent public witnesses during the search procedure of the suspected person, and to which they gave their consent. On being asked, they introduced themselves as Sri Ratan Mondal, son of late so-and-so, and Sri Shubham Dash. That thereafter the team of NCB along with 2 independent witnesses mounted surveillance in front of the city center 2, Action Area IID, Newtown area, Kolkata 136. At about 15 hours, a taxi stopped near the exit of the by lane in front of city center 2. An African individual got down from the taxi and stood by the roadside there. Immediately, the NCB team surrounded the said individual and went on to ask his name and nationality. To this, the person replied that his nationality was Nigeria and further showed his passport. Then the NCB team members introduced themselves by showing their respective government identity cards and also the independent witnesses. On being asked about his identity, the person introduced himself as James Kevin Edward, male 28, a Nigerian national, by showing his passport bearing number such and such. Then the NCB team informed him of the input available with them and of their intention to search. That thereafter, the NCB officers informed the said person in writing of the provisions under Section 50 of the NDPS Act 1985, per which he had the legal right to tender his personal search before any magistrate or gazetted officer empowered under Section 42 of the NDPS Act 1985, and also the right to search every member of the NCB team as well as both the independent public witnesses present before him prior to his own personal search. He was further intimated that a gazetted officer, Sri Shantanu Aich, was already present in the team. Subsequently, James Kevin Edward replied in writing that he neither wanted to be searched before any magistrate or gazetted officer, nor did he want to search the team members of NCB of the independent.
He did not exercise his authority, his right. There is a judicial decision. He did not exercise his right to be searched in presence of. He refused.
My lord, the petitioner is a Nigerian national. My lord,
I only know this judicial decision if he has been informed and if he has refused to be searched. So he has.
My lord, if your lordship kindly takes up Ishdan Sheikh once. My lord, I have annexed to my written notes of argument, which states that it is the duty of the team of the prosecution.
Even if he refused to be.
My lord, he has to be given an option.
He has given option. I want to know from what is the current law.
My lord, he has to be made aware of the consequences, that what can happen if he refuses to be searched in front of a magistrate or a gazetted officer. And a person who is a.
For what purpose your client has visited India?
My lord, that has not come in the in the ambit of the prosecution case. It has, my lord, if it is not there within the 4 corners of the paper book, my lord, I cannot explain.
There is no evidence.
My lord, no, there is nothing. My lord, I did not. My lord, the very purpose of the thing is that if the if the person who has received the information, he himself has laid to the search and seizure.
This was the Ismail Sheikh judicial
Yes. My lord, will kindly comes to page my written notes of argument, my lord.
I said written notes of argument.
My lord, we both have filed our written notes.
Application. Yes. This was the judicial decision.
Yes. My lord, first, if your lordship kindly comes to page 16. My lord, I will, wherein Paramanando's decision has also been cited and Jadeja's decision has also been cited.
16.
My lord, 16.
16 Kashmiri law. 16 of what?
My lord, of my written notes.
Yes. Kashmiri law. State. আরে এটা তো আপনি কার্ডটা দিলেন, আমি বললাম এটা দেখেছিলাম।
My lord, I have an extra copy. May I hand it
It's
over?
there, it's there. দেখুন এরকম একটা কিছু লাগানো থাকবে, হ্যাঁ।
হ্যাঁ, পরমানন্দ আর ইশদান শেখ।
Yes, 16.
Has my lord got it? My lord, Ishdan Sheikh. My lord, if your lordship kindly comes to
High Court of Judicature at Calcutta.
page 19. My lord, the relevant paragraphs are paragraph 15 to 18. ইশদানটা রিলাই করছে আগে, ওখানেই তো পরমানন্দ বলে দিয়েছে। My lord, in paragraph 15 of the said judgment, my lord, the citation of Paramanando and the my lord, relevant paragraph was relied on. My lord, it has been stated, observed, in state of Rajasthan versus Paramanando and another, negating the argument on behalf of the prosecution that an offer to be searched before the nearest magistrate or gazetted officer or a gazetted officer of the raiding party is a valid compliance of section 50 of the Independence Act. The court held as follows. We also noticed that PW10 SI Qureshi informed the respondents that they could be searched before the nearest magistrate or before the nearest gazetted officer or before PW5 JS Negi, the superintendent, who was a part of the raiding party. It is a prosecution case that the respondents informed the officers that they would like to be searched before PW5 JS Negi by PW10 SI Qureshi. This, in our opinion, is again a breach of section 50 subsection 1 of the NDPS Act. The idea behind taking an accused to the magistrate or the nearest gazetted officer, if he so requests, is to give him a chance of being searched in the presence of an independent officer. Therefore, it was improper for PW10 SI Qureshi to tell the respondents that a third alternative was available and that they could be searched before PW5 JS Negi, the superintendent, who was a part of the raiding party. PW5 JS Negi cannot be called an independent officer. We are not expressing any opinion on the question whether it is whether if the respondents had voluntarily expressed that they wanted to be searched before PW5 JS Negi, the search would have been vitiated or not. But PW10 SI Qureshi could not have given a third opinion to the respondents when section 50 subsection 1 of the NDPS Act does not provide for it, and when such opinion would frustrate the provisions of section 50 subsection 1 of the NDPS Act. On this ground also, in our opinion, the search conducted by PW10 SI Qureshi is vitiated. Paragraph 16. In the present case, the appellants were misled by the incorrect offer given to them that they could be searched by a gazetted officer who is a member of the raiding party. A gazetted officer who had proceeded to the place of occurrence after entertaining reasonable belief that the accused persons may be carrying narcotic substance.
Mr. Chakraborty, this is distinguishable because in present case, it was not told to the accused that you can be examined in front of a gazetted officer who is a member of the raiding party. That's not the case. Had he agreed, he could have been taken to an independent gazetted officer.
My lord, in my case, my lord.
Yes.
My lord, in my case, it was said that my lord, Shantanu Aij was a gazetted officer present with the raiding team.
Oh, that was the
Yes, my lord, your lordship will kindly see.
Why is the deposition of PW1?
PW1.
Yes, deposition of bulletin is here.
My lord will kindly seize page 18.
Page 18 of
The paper book. Page 18. 1, 2, 3, 3. Last but third paragraph. My lord, last but third paragraph of page 18.
Page 18.
Yes, ma'am. It is of PW1. Last but third paragraph. He was also informed that one gazetted officer was already in the raiding team.
No. Why is the notice?
My lord, that your lordship will find there are 2, 3, 4, 5. Last but fifth paragraph.
Exhibit
3 by 1.
Why is the notice sir? What is the notice sir?
My lord, This is the.
No, I have handed over, in fact, I handed over the exhibit list. Exhibit 3 is the section 50 notice.
That notice has to be exhibited.
Yes,
Sec-
it was in the file.
In the file, exhibit file. Exhibit file টা একটু দিন।
What your lordship,
My lord এর কাছে?
what your lordship is thinking that why did he refuse? My lord, kindly see from the exhibit 3.
Want to be searched. Presence of magistrate. এখানে কোথায় বলা আছে যে শান্তনু আইচ ওয়াজ প্রেজেন্ট, শান্তনু আইচের সঙ্গে
এভিডেন্স তো বলতে
এভিডেন্স ঠিক আছে
কি সেটাই কমপ্লায়েন্স অফ সেকশন 50 হচ্ছে।
Yes. So there is no in the notice there is no mention that you can be searched in presence of Shantanu Aich.
My lord, it has come in the deposition. My lord, he has admitted that he was informed that one gazetted officer was already in the raiding team. My lord, this subject to lordship's correction, my lord.
He was also informed that yes, one gazette, but you can be searched in his presence. It has not been one gazetted officer is present.
Also present in our team. My lord, just before that.
No, there is no suggestion or no intimation that if you wish, you can be searched by in presence. That is not here.
My lord, if your lordship kindly, my lord, if your lordship kindly sees the preceding paragraph. Thereafter, he was told that if he wished, he could be searched in presence of any magistrate or gazetted officer provided in section 42 of the NDPS Act. Just soon thereafter, he was also informed that one gazetted officer was already in the raiding team. My lord, this option in itself, subject to lordship's correction, is my lord vitiates the search and seizure. My lord, I am not on my lord, if the section, my lord, your lordship can. My lord, the moment he was said that he can be searched in presence of a magistrate or a gazetted officer, he was told that we already have a gazetted officer in our team, and that gazetted officer was a person who received.
Cannot add anything in the evidence.
My lord, it is there.
Strict interpretation, we cannot add anything.
My lord, it is there in the evidence.
This is my
I bow down to your lordship. My lord, just here he has stated that he was told that if he wished, he could be searched in presence of any magistrate or gazetted officer. The soon thereafter, he was also informed that one gazetted officer was already there in the raiding team. My lord, subject to lordship's correction, my lord, in Ishtan Sheikh, my lord, this honorable court has thus been pleased to hold that, my lord, such an option in itself is bad in law.
There's no option in the notice.
My lord, such a my lord, explanation, my lord, such a my lord, thing to make the person understand, my lord, that itself is bad in law. And my lord, Shantanu Aich, who is a gazetted officer, is PW 4.
He's right. Yeah.
Shantanu Aich. Page 32. Well, at PW4. On 4-1. Well, not much, my lord. Only this. Yes. On 4/1/2018, I was posted at the NCB KZDU, Kolkata as superintendent. On that date, at around 11:30 hours, the then zonal director, Dilip Kumar Srivastava, called me in his chamber and in.
Relevant portion, which you want to show. He was in the raiding party. That
Yes.
is there.
And he acted as a gazetted officer, that is also there.
Why? That the accused has been asked with searching his presence. Is there anything? He was present in the raiding team.
Yes. And he was a person who acted as a gazetted officer to the search and seizure. My lord, that is a thing that has come up. So, my lord, my humble submission is that the search itself, since it was conducted in the presence of a gazetted officer who has led the raiding team, is vitiated. My lord, another point. My lord, the articles which were seized on 4th of January 2018, the sampling was done on 4th of January 2018. It was produced before the learned magistrate on 5th of January 2018. And thereafter, it was sent to the CFSL on 8th of January 2018.
So 52A or something like that.
My lord, on 4th January, when the sample was seized, the inventory on the next day, 5th of January. And thereafter, in the interim, on 6th and 7th, it was not sent to the CFSL. It was sent on 8th. Explanation has come that since 6th and 7th were Saturday and Sunday, we could not send it to the CFSL, so we have sent it on 8th of January. So, my lord, this
acceptable explanation or not?
My lord, to my humble submission,
Sunday will be open.
my lord, Saturday and Sunday, my lord, when it was the Malkhana register, my lord, was also not exhibited. Malkhana register to exhibit hoyni. Malkhana register to exhibit hoyni. My lord, Malkhana register was not exhibited to show the movement of the samples. So, my lord, section 52A, there is also a violation. So, my lord, and out of 10 years, I have already undergone 8 years, nearly 8 years of punishment. 1 month more to go.
Mr. Bhattacharya, we'll come back at 2 o'clock.
Yes, yes.
10 minutes, nothing more. You will only have to satisfy us on the point of Ishdan Sheikh.
Because there are
The two paragraphs of PW1 read together.
Per incurium.
What is per incurium?
Just check. Lord,
I see.
cannot
That
look
you show us, that we don't know.
cannot look into it.
That you show us.
Supreme Court says Section 50 has no application here. Say why? Where is Section 50 applies? Personal search.
Yes.
He had voluntarily handed over narcotics. Where is the necessity of personal search? Where is the existence of personal search? And Ichashet facts is the narcotics was recovered from the bag. Section 50 has no application from the bag, recovery from bag. Section 50 only applies when it is personal search. So it's per incurium.
Other than matters be listed again on Monday under the same heading. So if in the meantime, the appellant in CRA 676 of 2019 files an application, the same shall be listed along with these matters. File, give the number,
My lord.
be listed.
My lord, we are deeply obliged, your lordship.
Item number 28.
Chalo.
नहीं. Item number 29.
Led by Ms. Rituparna Ghosh, my lord. It is our renewed application, my lord, praying for bail.
When was it dismissed?
My lord, the last application, my lord, CRAN 1 was dismissed in April of 24, my lord.
What is the conviction for?
My conviction under 302, my lord, sentence for life. But I will start with the matter, my lord. Ms. Ghosh is on.
How long you are in custody?
My lord, we are in custody for 19 years and 2 months, my lord.
19 years?
19 years and 2 months, my lord.
When was the conviction?
My lord, the conviction was in 2022. I was an under trial.
2006, faced custody trial.
15 years in custody while being in trial, my lord. Thereafter, I have continued.
But the appeal is ready, my lord. Can be heard or
My lord, the appeal has been.
already 19 years, my lord.
The appeal may proceed, my lord, but given the circumstances, my lord, let the petitioner be on bail, my lord. Thereafter, the appeal can be heard, my lord. My lord knows, my lord, the directions of the Supreme Court, my lord.
Last year it was turned down on that.
My lord,
What is the direction of?
my lord, we are relying upon the judgments of Khublal, my lord, and 2 other judgments passed by this honorable court, my lord, where the appeal has a possibility of being heard out, but the appellant has suffered has spent a substantial time in custody, my lord.
Not same was a circumstance in 2024 when the
19
bill was
years.
turned. My lord, I am
19
saying
years, 2 months,
it's
my lord.
turned down last year. Similar circumstance because he was in custody for 18 years.
देखिए दाओ file to दाओ.
Turned down.
Where is that order? Where is that order?
My lord, the order is.
But I'm not going on merit since he's in custody for 19 years. But similar was the circumstance last year when it was turned down. But we kindly go to the last order for one.
My lord, the order is in page.
Page number?
My lord, I'll just.
Page 17, 51.
It's page 17, my lord. It's the first annexure, my lord. It's 10th of April 2024, my lord.
Was in custody for 17 years at that time.
No, it's good. The problem thing is, if you look at the order, the coordinate bench records, appeal paper books have been prepared, appeal is ready for hearing. So implicit in this sentence is that appeal will be heard shortly. We can't promise that. Appeals of 2015, 2016 are pending. That is the point. So even after this appeal could not be heard for 1.5 years. Saudan Singh, what is it?
My lord, Khublal and Saudan Singh. My lord, Saudan Singh is the judgment where the Supreme Court had directed the High Courts to prepare a list of all the convicts more than 14 years, my lord.
Have the copies.
My lord, I have the copies, my lord.
We are not on merits at all, Miss Gould. We'll record that there was a rejection. We'll record everything.
No.
Where's Khublal?
There is a judicial conviction.
Milo.
Which was later retracted, my lord. Judicial conviction was later retracted during the trial.
There are a
There
number
was
of
an
witnesses.
extrajudicial confession.
My lord, there was first an extrajudicial confession. Thereafter, my lord, there was a judicial confession which was retracted during the trial, my lord.
A number of witnesses who have last seen them together. The body was
My
never
lord, the body was never recovered.
thrown into the river. The body was never recovered.
You are this time?
This second.
No principle of law has been laid down in Khublal. Anyway, hey, the appellants, both the appellants have
Well, one has expired during trial.
oh,
There's one before your lordship.
there's only one appellant.
Mohammed Nurain.
I see. The appellant renews his prayer for suspension of sentence and grant of bail in an appeal filed by him against a judgment and order dated February 21, 2022, passed by the learned additional district and sessions judge, first fast track court, Bichar Bhavan, Kolkata, Calcutta, in sessions case number 127 of 2006. Stop. By the said judgment and order, the appellant was found to be guilty of commission of offense. Lomba judgment.
364, 302, 201, 30.
Was an offense under section 302 and 364.
364, 302, 201, 34.
Under sections 302, oblique 364, oblique 201, oblique 34 of the IPC, and was sentenced to suffer life imprisonment, and was also fined. Stop. His application under section 389 CRPC for suspension of sentence was dismissed by a coordinate bench by an order dated April 10, 2024. Stop. He has now renewed his prayer. Paragraph learned advocate for the appellant oblique applicant says that he is in custody for
19 years and
19 years, 2 months. Stop. Nobody can say when the appeal will be heard. Stop. There are various loopholes in the impugned judgment and order. Stop. The appellant has a fair chance of succeeding in the appeal. Stop. In the event the appellant succeeds, nobody will be able to give him the time that he has lost in incarceration. Stop. The appellant therefore prays for suspension of sentence pending disposal of the appeal. Paragraph. Learned state advocate tells us that there is sufficient incriminating evidence against the appellant. Stop. A coordinate bench rejected the appellant's prayer for suspension of sentence only a year and a half ago on the grounds recorded in the order. Stop. It is a case of culpable homicide. Stop. No leniency should be shown to the appellant, oblique applicant. Paragraph, we have considered the rival contentions of the parties as also the material on record. Stop. We see that the appeal was filed in 2022. After, and the conviction was
2022, Mike. The trial went on for 16 years.
2022 itself. Equivalent. After the appellant was convicted on February 21, 2022. Stop. The trial continued for 16 years.
And
Stop. The appellant.
at the time when the offense was committed, this appellant was only 25 years. So
Stop. The appellant was in custody throughout the trial. Stop. He was only 25 years old when the alleged offense was committed. Stop. Paragraph. Nobody can say with any certainty when the appeal will be heard out. Stop. There are appeals pending which were filed much prior in point of time. Stop. Those appeals need to be heard out also. Paragraph. In view of the aforesaid, keeping in mind the long custodial detention of the appellant, and in view of the decisions of the Honorable Supreme Court in the cases of প্রথমে কাশ্মীরা সিং দেবে এটা reference, remember citation
Kashmira Singh,
কমা তারপরে এইটা দেবে খুব লাল তারপরে এটা সৌদত সিং comma, without touching the merits of the case, we are inclined to allow the applicant's prayer. What a petition of the applicant now.
There is provision for mandatory parole or something like that after 14 years. There are provisions. Parole. There is a national legal services authority. After 14 years, we have to bail out.
20 years.
After 14 years.
14 years.
After 14 years.
See the new section.
New section.
Yes.
আরে ওইটা আছে
BNSS.
BNSS.
BNSS. Then yes, please read.
What about it? ক্রিমিনাল অ্যাপিল করতে বিএনএসএস নেই অসাধারণ
Well, it's UT under trial. The principle laid down.
এটা বিএস বিএনএসএস আইনি ছিল তো
436A.
বিএনএস
That's one.
এটা বিএনএস
No, 436A did not do mandatory for 7 years.
এটা বিএস
And third was not there. It was mandatory. This has become mandatory. And they can imprison for life to be 20 years. So, well, reasonably, your lordship can.
Yes, that's what I'm telling.
Yes.
There are provisions, there are circular from National Legal Service.
No, that is true. That is true. That is
Parole.
that
citation time. SCC 79(3), SCC 428. State of Punjab.
পেপার বুকস আর রেডি
Yes, ma'am.
হ্যাঁ পেপার বুকস আর রেডি আচ্ছা আরেকটা অ্যাড করে দিও we further see that although the coordinate bench recorded in the earlier rejection order that the appeal is ready for hearing, the appeal has still not been heard.
No,
Ma'am,
my
this
lord.
appeal was running in the list since long, my lord. It was running in the
And
list.
it was also, my lord.
Not been heard.
No, it was started being heard.
It was
It was
being
started also. Yes, ma'am.
But my lord, it couldn't be heard.
has not been disposed of.
Yes. But it was heard, ma'am.
Usually, the appeal. When will you do the appeal?
Subject to satisfaction of which court?
My lord, CMM, learned CMM, Kolkata.
Yes, where does he stay?
My lord, whenever CJM Calcutta.
Where does he stay? Where will he stay?
My lord, now he is in Kon jail hai? Kolkata.
It's Bow Bazaar. His address is PSB.
Mrs. Bobajar.
No, no, he is staying in jail.
He was
He is in Presidency Correctional Home.
Yes.
condition, Jita.
Condition, where will he be staying now?
Boro Bazar.
Boro Bazaar. So we will not leave
Yes,
the
yes.
metropolitan limits of Kolkata. Meet the IC Boro Bazaar once in a month.
Once in a month.
Lord will list this appeal.
Hmm?
List this appeal on
4 weeks.
A monthly list of December.
Hmm?
Monthly list of December.
Yes, বলে দাও তাহলে monthly list of December করে দাও. Let the appeal appear in the monthly list of December.
Much obliged.
Item number 30.
Yes.
Lordship, I'm for the appellant. And so, in the nutshell, Lordship, the appellant is the husband of the victim, and he has been convicted under 302 of IPC.
For killing his wife. For killing his wife.
That's the apparent finding, Lordship. Now, the FIR, Lordship, was lodged against the husband, the mother-in-law, and the mother of the mother-in-law.
You're applying for the first time or it's a renewal?
Lordship, first time.
First time.
And thereafter, FIR was lodged under 498A, 307, and 34 of IPC. Thereafter, the incident took place on 16th of, what was it? April 2013. The victim expired on 22nd April. And after the death of the victim, the charge sheet was filed under 498A, 302, and 34 IPC against the husband and the mother-in-law. Now, trial took place. The mother-in-law was acquitted from both the charges, 498 as well, 302. The husband was acquitted from 498A, but convicted under 302.
Dying declaration is yes.
That's what the court has considered, but I have issues with the dying declaration, and I would like to make submissions on that. So, if your lordship wants to, before I get into the dying declaration, lordship, if you could take up a few of the depositions, lordships. The de facto complainants.
You were on bail or custody trial?
No, on bail.
You were on bail?
I was on bail. After 3 months in custody, I was granted bail. The trial took place for over 10 years, and there was no adverse report against
Any adverse report, Mr. Keshri?
No, my lord, no adverse report as such, but the paper books are ready for hearing.
That's all right. How many appeals can we hear out? Tell us.
This is not a case where, my lord, he's been in custody, languished in custody for a long time. He's been in custody.
How long you in custody after conviction?
Since 19th January 2023, he's in custody.
2 years, 10 months approximately.
No, I want to see the dying declaration.
My lord, page 3 of the paper book. Question number 7.
20?
Page 3. Question number 7. Page 3.
This is treated as the dying declaration, a statement made by the victim to an SI.
By the police officer? Or?
Yes, Lordship.
So, in the presence of
So rightly done by putting question and answer form.
I would.
Why suspense? What is how long?
I see.
Mother-in-law was acquitted, or?
Yes.
Mother-in-law was acquitted?
Acquitted.
All charges.
All charges. And the husband was acquitted of 498.
I think because of question number 7, in the
Lordship, in order to fully appreciate, yeah.
My husband Taposan has poured kerosene oil upon me and then set fire on. My mother-in-law was also along with him. She did not take any part.
So since she ascribed the specific role to the husband, he was convicted.
The mother-in-law has been acquitted. There's no appeal, as per my knowledge, according against the order of acquittal.
Very, very clear. What do you have to say on this?
Yes, Lordship. Lordship, if Lordship allows me 1 minute, I would just take your Lordship through a few depositions. First is the deposition of the de facto complainant.
Yes.
If your Lordship takes up page 10 of the paper book.
Yes. Yes.
The sister of the victim.
Yes.
Vandana Haldar. If your Lordship comes down to
we are not. I am not. I do not want to see the other deposition of other witnesses. I want to concentrate on drying declaration.
Just the dying declaration.
The main witness, that is the Aparna Jana, cannot be called in doc.
The dying declaration was.
Whether dying declaration is properly done or not.
I have my issues with that. The
one second. এটা হচ্ছে ব্যক্তি একবার এসো প্লিজ we expected the page here. No, sorry, Peter. No. PW1. Thereafter, her husband, Tapush Jana, Mathalit Lakatchen, started torture.
Just because Lordships were on PW1, there are two other prosecution witnesses who have claimed that she has committed suicide at the time of admitting the victim to the hospital. It was declared that she has come as an accidental stove burn injury.
Stove burn injury?
Yes. If Lordship takes up PW16, the doctor, they are not with the...
No. You said stove was busted. Why is the stove was seized? I want to know.
Lordship, the difficulty that I am having, Lordship, is that the paper book does not contain a lot of the exhibits. So my hands are kind of tied because the Caesar list has not been exhibited, the chart sheet has not been exhibited, has been included in the paper book.
17 documents exhibits have not been attached as a part of the paper book. 17.
But then you have to cure that defect then.
It has to be.
File a supplementary paper book if you have those documents in your custody.
Files are here. The exhibit files are in original before Lordship.
Oh, I see.
There is no...
That can be inspected anytime.
You are taking
It's never...
that So was bust. Then the IOS would have seized that.
Not never
That is not there.
After
Only
this,
I do not find only the daughter-in-law suffered injury. Neither mother-in-law suffered any burn injury.
Yes, she did.
In every matrimonial
She did.
home,
She did.
where is the 498A? I never come across any issue. The mother-in-law was burnt. Only daughter-in-law was burnt.
Mother-in-law was also burnt. That comes from the deposition.
I am not going to allow your prayer right now only because of the dying declaration.
Lordship, may I satisfy your Lordship about the dying declaration?
Yes.
The dying declaration, if your Lordship comes to the dying declaration, the second page of your Lordship's, the paper book, it was recorded by S.I. S. Roy in presence of Dr. J. Roy. That's page number, Lordship.
page 24 of your Lordship's paper book.
No, 3 and 4. Page 4 contains who took the dying declaration. Now, it's very interesting, Lordship, it doesn't contain the time of recording. Now, Lordship, if Lordship takes up the formal FIR, the information was received at 10:05 hours in the morning.
Who took this victim to the hospital? Who took this victim to the hospital?
As per
PW1 and her husband.
Why you are not?
I was there as well. It doesn't transpire here. I was there. Unfortunately, Lordship, it transpires from the 313. Lordship, if I may just go through the deposition of the IO, the recording.
We will hear the matter.
Lordship, indulgence of 1 minute.
1 minute, yes.
1 minute, Lordship. Then I'll right away come to the deposition of the Dr. Lordship.
24. W.E. J. Roy. 24.
What is the percentage of burn injury?
90% burn.
Then police has to record as per rules of Calcutta police.
Yes. Yes.
It has to. There is no chance for calling. There is no time for calling magistrate.
I'm not on that, Lordship.
Asking this question to you so that
Yes. No, the 164 statement was recorded.
burn injury.
Lordship, 164.
Police has rightly recorded this statement, according to my estimation.
The magistrate has also recorded 164 statement two days later, which has of the victim. 164, of course, of the
164 of the victim.
Yes, that is not with the paper book.
It has not been proved.
That is to what effect?
There are some contradictions.
Where is it?
It's not in the paper book, Miller.
So who will file this paper?
How
The
do-
department filed it.
How do we get it then?
Well,
Is
that's
it-
in the exhibit file must be. If my learned senior friend
So
says
it has been exhibited.
It has been exhibited.
Then you go through we allow you to go through the exhibit file. The original is here.
So
Come back tomorrow.
Then let me inspect, Lordship. and then-
Inspect, mark the documents, show us. We have heard learned advocate for the applicant oblique appellant at some length. Stop. This is an application for suspension of sentence and grant of bail pending disposal of the appeal. Eta age dao, tarpore second paragraph. We see that there is a dying declaration of the victim lady who squarely implicates the appellant. Stop. Paragraph. Learned advocate for the applicant says that the concerned magistrate also recorded the statement of the victim lady 2 days after the alleged incident. Recorded
3 days after the
3 days. Recorded the statement of the victim lady under section 164 CRPC. 3 days after the alleged incident. Stop. Such statement is not in the paper book that has been filed. Paragraph. Learned advocate on record for the applicant is requested to go through the exhibit file and come back with proper instructions on the next day. Paragraph tomorrow or day after tomorrow.
Tomorrow is okay.
Kalke diye dao amongst the first 5 items under the heading bail in connection with appeal. Actually, at the top করে দাও, এটা শুনছি যখন আমরা as the first item under the heading. তাহলে second item.
Very well, Lordship.
Keeping it tomorrow.
Obliged, Lordship.
Morning. তারপরে 164 করে সেই একবার এক্সিবিট ফাইলটা দেবে একবার এক্সিবিট ফাইলটা দেবে না
Item number 31.
31.
Madam, for the state.
Pass over.
Item number 32. I am for the appellant.
32, Your Lordship, I'm for the state. I'm praying for an adjournment. Kindly the matter be fixed on next week. Kindly the matter be fixed anytime next week. On the last occasion, Your Lordship has directed us to serve a copy upon the de facto complaint. We are yet to receive
What,
the
376?
box.
Oh, service is not complete.
Service not completed.
Monday.
We didn't got a report from the
Monday.
police station. Deeply obliged.
Learned advocate for the state says that the de facto complainant is yet to be served as directed by this court. Paragraph. Let this matter be listed again on Monday করে দাও, retaining its position. Monday data দিয়ে দাও, retaining its position.
Grateful. Grateful.
Yeah. Item number 33.
Your Lordship, I am for the state. This matter is pertaining to POCSO Act, Your Lordship. I have gathered information from my learned friend that he has not served upon the victim.
You're not served.
My lord, perhaps served, but the affidavit of service is, my lord, if I shall be highly obliged if she serves, my lord.
Serve, Your Lordship.
This is an application for suspension of sentence in an appeal preferred against an order of conviction under section.
My lord, section 376 2I read with section 4 of the POCSO Act.
376 2I IPC.
It's a legal aid, my lord,
Read with section 4 of the POCSO Act. Paragraph. Learned advocate for the appellant says that the victim girl would not be served. Paragraph. Let the state effect service on the victim girl and file service report on the
Yes,
next
Your
day.
Lordship.
Monday.
Tuesday.
What is the address?
My lord, it is in Poshchim.
Poshchim?
Your Lordship, the address
Bankura,
is
my lord, kindly excuse, Bankura.
Bakura. Monday.
Monday.
Monday. Tarik diye da Monday.
Item number 34 to 36.
Lord,
In 35, I am appearing on behalf of appellant.
item number 34, my lord. My lord, Mr. Anirban Mitra is appearing on behalf of the appellant. My lord, we just received NOC
No, my lord.
from
What has happened, my lord? There is
Astral
my lord, two
advocate.
appellants, my lord. Appellant number 1 has taken the Wakalat number for no objection from me, but I am appearing for in respect of appellant number 2.
Yes, my lord. Appellant number 1.
Appellant number 1.
Yes, my lord. We just received, my lord,
And I have
NOC,
filed-
but
I have-
we have not received any paper regarding this appeal, my lord.
There are 3 appeals.
Three appeals.
Three appeals,
Three appeals, my lord. In item number 34, my lord, there is, my lord, two appellants, my lord. I have filed the appeal, my lord, in respect of two appellants, my lord. Thereafter, my lord, appellant number 1, my lord, have.
So there are 4 convicts.
Yes.
Lordship.
No, 4, no, 6 convicts.
Don't say no, there are 4 convicts. Yes. Arithmetic says so.
Lordship.
We have understood. In the first appeal, 2 appellants. You were appearing, representing both of them. Now one has taken change from you, has gone to Mr. Anirban Mitro. They have received the NOC.
No, see, my lord, just today, my lord.
Today, when will you do it?
So, my lord, we have no copy of the papers regarding this matter, my lord. So, we just pray for
Please
3
supply.
weeks time.
Since you have given no objection, please give them papers also.
Lordship.
Well, more than 12
Excellent.
years, my lord. we
At
have.
the outset, I beg to draw the kind attention of this order passed by this honorable division bench in Abdar Sheikh versus the state of West Bengal.
You are appearing on in which item?
35, Lordship.
Let the 34.
Lordship.
So when will you do it? When will you give him the papers?
Yes, today.
Aske diye din na.
Today.
Give her the papers today. Come back on Friday.
Okay, yes, my lord. Friday.
Friday.
My lord, we praying for 2 weeks time.
Are aaj ke Southern Second Kashmira Singh, my lord.
Because we have no knowledge regarding this matter. We don't know.
How long are you in custody?
More than 12 years, my lord.
13 years.
Yes, 13 years, my lord.
Then
75 years old I am, Lordship.
Yes.
75 years I am.
Yes, my trial is
come
also
back
so.
day after tomorrow. We'll see.
Yes, my lord, day after tomorrow.
If you are not ready, we'll take up the other matters. Thursday করে দাও সবকটা. You are not recording an order. Give her the papers. Or
বেল হয়ে যেত আজকে
Item number 37. And 39. 38 and 39. 38 and 38.
38 Mr. Soubik with appearing, my lord, but due to some personal difficulty, my lord, he has left the court, my lord. Kindly fix it on Thursday, my lord.
on the prayer made on behalf of the. He is appearing 38.
38.
39, who is appearing?
Right.
You don't know. Prayer made on behalf of the appellants in CRA DB 223 of 2024. Let these 2 matters stand adjourned till Thursday. Date the other.
After that.
Item number 40.
Next.
Item number 41 to 45.
Which one? 41?
40. But I for the appellate.
Oh, 40 or for the appellant?
Yes.
Oh,
40.
he says not today. On the request made by learned state advocate, let this matter stand adjourned for the day.
The circumstantial evidence.
Always sinner is appearing for these status.
The circumstantial evidence case.
Which one, Maharaj? Yes, circumstantial evidence.
Circumstantial evidence.
Right. Well, the best part is the FIR was sent to the magistrate after 4 days.
Nobody saw Amina Bibi commit the offense.
Absolutely right.
And only one person saw that
She was running away.
bloodstained clothes.
Yes.
That bloodstained clothes had been seized.
No, nothing. Well, I'm so grateful. I wish I had Dr. Justice Sinha Roy's, my lord.
But you did not have any criminal division application whenever
I will do it.
You did not.
I will. Well, I don't know why. I don't really, I'll be honest with your lordship. I am not getting the zeal to work. But I have to work. Because I will, like your lordship's 8 figures not in the bank. That's the problem.
No,
You don't know any arithmetic at all. Where do you get 8 figures? 8 figures. Oh, she's come, my lord. You'll do it.
My lord, huh? Are you ready? Huh? Well, I don't think to say anything more.
So I have a question. The Amina baby, it's a circumstantial evidence. Nobody saw her to commit the offense. Only one person saw her to flee away from the place.
Why took you saw?
With bloodstained clothes. Now, whether these bloodstained clothes have been recovered, is there a seizure? Only pinium or iron rod
yes.
From the place of occurrence.
This is how we spend our evenings till 11 o'clock.
But only
8 digits. But we actually 5 digits.
नहीं सीधे नहीं.
So you take instruction, then come back.
आज किसी ने instruction नहीं.
तुम्ही बोलो, तुम्ही boss. एखाने state boss.
You need time to prepare yourself for.
There is no such.
Caesar.
That we're not seeing.
How long in custody?
The appellant.
My lord, I was always on bail since my lord 2010.
Conviction in?
Conviction was given, my lord, on the 22nd of June 20th of July 2024. 1.5 years. Right? 1.5 years. No, those were never recovered. And the lady. नहीं बेटा नहीं कहते की व्यापार आज के थर्सडे थे कौन से बेच है I'm calling you. अब अगर टाइम ना बना नहीं अपनी एक great lady growing young day by day.
Why not actually? That that's it. Very
हाँ बेटा नाम
that's it. And
That's the. She also admits that there is no allegation that the petitioner ever misused or abused the privilege of bail or jumped any condition of bail during the trial. paragraph. Having considered the facts and circumstances of the case and on a prima facie assimilation of the evidence on record, and keeping in mind that the petitioner was all throughout on bail during trial, comma, we are inclined to allow her prayer. Condition is with the
CGM Donglu.
And where address
Of the lady mother?
Shall not be
Of
leave
no,
court.
district
Oh,
accepting body.
court proceeding.
CGM
Ada ডাকো ক্রিমিনাল ঠিক আছে এটা ক্রিমিনাল
আর একটা হয়ে যাবে তো একটা
Item 41 to 45.
My lord, I am for the defect. Well, I am for the defect. Well, I am for the my lord, only in item number 43 CRAN application is there.
41.
Well, 41 to 45 there are 5 appeals out of the same judgment. In item 43 there is a CRAN application. My lord, I will be moving that application.
You are in 43.
My lord, I am there in from 41 to 45,
All.
but 43 I will be moving the CRAN application. My lord.
You are where? In which matter?
My lord, I am the de facto complaint.
You are de facto. You are for the state in all the matters. 43, the one, Mr. Sinha.
Only.
Chalo.
My lord, in this case, my lord, I am handing over the copy of evidence, my lord. My lord, kindly pardon me, my lord, there are certain, my lord, notings, my lord. My lord, 19 persons were placed on trial. My lord, charges were under, my lord, 147, 149, 323, 325, 307, 354B, 379, 302, and my lord, 506. All the 19 persons were acquitted of all the charges except 302. And instead, my lord, the common object part, the learned judge did at the time of conviction, altered the charge to common intention from common object 149 to 34 without giving opportunity to the appellant. My lord, the usual process is, my lord, the charge has to be altered and the appellant has to be heard on that because the new charge was there 34. But that was not done. At the, my lord, your lordship will kindly comes to the last page of the judgment, my lord, when, my lord, page number 33 of the judgment.
Yes.
Your lordship will see paragraph 90. In this case, one thing which I find that the charge under section 147, 149 with the other section IPC has been framed against accused persons, but on the facts of this case, there can be no difference between the object and intention with which the offense was committed. In such circumstance, in view of the proposition in law such and such, I am of the view section 34 in place of 147, 149 IPC is required to be substituted and it will cause no prejudice to the accused. But that has to be, my lord, a charge has to be altered and, my lord, hearing has to be given to the appellant before, my lord, this. That was not done. Just at the penultimate paragraph.
What is the prejudice caused to you?
My lord.
What is the prejudice? Please, that's why I have been prejudiced.
My lord,
this is a law, you know.
My lord, I will show from the evidence. I will show, my lord. Now, my lord. Now, my lord,
so that for altering this charge, you have suffered.
I will show it to your lordship. My lord.
Okay.
Now, my lord, 14 persons were acquitted. 19 were placed on trial. 14 were acquitted. Rest of the 5, all the charges, my lord, under section, my lord, 325, 307, 3.
It seems you'll take a little time.
Yes, my lord, someday.
3 o'clock, original side.
Tomorrow then.
Tomorrow. একদম উপরের দিকে যেন থাকে।
My lord, yesterday, my lord, your lordship has directed that it will retain its position, but it went down.
No, this peculiar computer system, they don't have control over it. Yes.
7 eyewitnesses appeal.
Well, I will show how out of 11, 7 are eyewitness.
Original side. Not from original side. You are from?
We are devout man. 2024 matter now. আরো পিছনে দেবে না একটু হবে
Real side matter to be mentioned item number 1.
Lord, this seems to be some erroneous listing, my lords. We have never applied for mentioning, and this is not in determination also. This seems to be some mistake, my lord. This matter is also already disposed of by.
Yes, it was mentioned yesterday by somebody.
My lord,
why are you nodding your head? Are we hallucinating? Apparently, it should be APOT instead of APO only for that correction. কে করেছিল মেনশন? ইনি তো করেননি, বুঝতেই পারছো। কিছুই জানেন না। এবার সে নেই যখন আউট অফ লিস্ট, যেহেতু
হ্যাঁ, go out করে দাও। Item number 2.
May please, Lords.
Lord, I appear in Lord the appeal. Lord,
I'm for the
please to direct us, Lord, to Lord prepare a short list of dates, Lord.
I'm for the resolution professional.
Mr. Jishnu Shah and Mr.
Yes,
Chaudhary.
Lord, I'm being
Yes.
Led by Mr. Chaudhary, my lord. He's on his way.
No, no.
That we have a list of dates, but my lord,
Mr. Shah, the matter of Mr. S.N. Mukherjee has been fixed at 3:30, but we'll hear you till 3:40.
Lordship is very kind. My lord, I had already indicated, my lord, what my challenge is. My lord, the challenge is, my lord, now with regard to the, my lord, declaration of MSME, my lord, status. Now, your lordships have already made a note that, my lord, the CRP, my lord, commenced on 22nd of August 2023. That, as your lordships had inquired, is the date, my lord, when the company petition is admitted, resolution professional is appointed, resolution professional takes charge. My lord, all the existing, my lord, management is, my lord, no longer, my lord, in management because, my lord, they are suspended. And as a consequence, my lord, it is only the resolution professional, no one else, who either himself or through his agencies can take decisions with regard to the company. My lord, this will become very important. Now, my lord, here, if your lordship now sees, my lord, what had happened is, my lord, here, as I told your lordship, that, my lord, our challenge was that, my lord, the respondent number 3 is a related party and is consequently barred by the provisions of section 29A of the Insolvency Bankruptcy Code from, my lord, submitting any resolution plan. My lord, as soon as I said that, my lord, that was met by, my lord, a response from, my lord, the resolution professional. My lord, that your lordships will find at page 296. That's at volume 3 at page 296.
Respondent number 3 is Reshmi.
Respondent 3 is Reshmi. But the intending, my lord, resolution.
Corporate editor is Jagadam.
Yes.
And you are Tech Nirman.
Yes, sir. My lord, your lordship will find at page 296, my lord, when I file a complaint, my lord, before the NCLT, saying that, my lord, Reshmi, my lord, cannot be considered because Reshmi is a related party. My lord, the resolution professional, my lord, files an affidavit. My lord, that affidavit starts at page 296.
Yes.
My lord, lordships will kindly come to paragraph 33 of that affidavit at page 308. My lord, this is for the first time that, my lord, the resolution professional, my lord, seeks to assert that, my lord, the corporate data company, which is Jagadamba Industries, my lord, was a registered company under the MSME provisions. And your lordships will now please have a look at, my lord, Annexure A, which is referred to in paragraph 33, that is the certificate of registration, that your lordships will find at page 316. So first assertion comes by way of, my lord, paragraph 33 of the affidavit, and the certificate is, my lord, at page, my lord, 316.
Where do we find the date?
My lord, your lordship will find, my lord, the date, my lord, at page 316, my lord, there are no dates here written. I should show your lordship, my lord, how discrepant, my lord, this
Date of commencement is there.
Yes, date of commencement is there, that is 1993.
25/5/93.
Now, my lord, date of commencement is 25/5/1993. But, my lord, that is where it stops. Now, my lord, so far as this is concerned, my lord, as soon as, my lord, they come up with this for the first time, my lord, we file, my lord, a rejoinder to the affidavit that is filed by the RP. And, my lord, that rejoinder, my lord, ultimately, my lord, discloses, my lord, proceeds to, my lord, say that, my lord, the MSME certificate, my lord, that was granted, my lord, we disclose that. Now, my lord, please come to page 321. This is, my lord, the certificate that we obtained from, my lord, the MSME portal and the certificate that we annex.
Mr. Shah, the date is at page 317. Date of filing is indicated.
So this 321 document you produced?
Yes, I produce. Now, my lord, here your lordship will find that the date of commencement is constant, 25th September 1993. But kindly I'll look at the bottom of the page. This Udyog Aadhaar Memorandum UAM certificate is valid till 30th June 2022. So, my lord, this certificate expired before the commencement of CIRP. And the CIRP commenced on 22nd August 2023. Lord, we also brought on record some of the documents, well, in our affidavit to show that, well, the industry had stopped functioning altogether. Your lordship will kindly see the next page, page 322. Well, this is a communication made by the West Bengal State Electricity Distribution Company Limited. Well, on our representation, this is, my lord, written to us. If lordship will see page 322, the WBSCDCL writes and says, you have approached WBSCDCL for information about disconnection date and outstanding dues of Jagadamba Industries Limited cement plant, since you are one of the bidders participating in the auction of the plant. Physical disconnection was executed on 8 August 2023 due to huge outstanding dues. Tomorrow, before commencement of CRP, electricity disconnected. And then also please see the next page, 323. Well, this is the other plant. Electricity disconnected on 22nd February 2019, page 323.
Yes.
Now, at this juncture, the resolution professional normal, when we bring on record the fact that the registration was valid only till 30th of June 2022, the resolution professional filed a fresh affidavit before the NCLT. And this affidavit discloses a new certificate. The affidavit starts at page 355. I need not trouble your lordship with that. Please see the new certificate that the resolution professional produces at 357. Now, this is very interesting. Your lordship will find at the bottom of page 357, date of Udyam registration is 25th August 2023. This is 3 days after the commencement of CRP. Now, the question is that after the commencement of CRP, it is only the RP and the RP alone who can take these decisions, make these applications either by himself or through his agency. The question is who applied for this UAM Udyam registration. Previously, it was Udyam Aadhaar memorandum. Now it is Udyam registration. Who applied for this on 25th August 2023? It is not their case that the application had been made prior to the commencement of the CRP. It was kept pending, and thereafter, the registration was granted. The question becomes very important because under provisions of section 17(1)(7), it is only the RP who can take steps. Now, the RP has gone on record to say, I did not do anything. Now, admittedly, this happens on the basis of self-declaration.
So RP, like the OL, steps into the shoes and controls everything.
Yes. But the provision of the law is now very clear. Old board is completely suspended. Old management is completely made defunct. Everything has to happen through the resolution profession. So, if today, I would have understood if it is the contention that the Udyam registration had been applied for before commencement of CRP, it was granted later, then one can understand. But that is not the case. Your lordship will find that applied for, granted on same day on the basis of self-declaration. The question is who makes this declaration? RP has said that I have not done so. Well, that becomes very important. I shall take your lordship through that. Now, thereafter, your lordship will see, an affidavit is also filed in the same application by Rashmi, respondent number 3. Now, Rashmi is interested because Rashmi wants to, ultimately pursue its application and, get its plan sanctioned and approved. Now, so far as Rashmi is concerned, now please see Rashmi's affidavit starts at page 359. And Rashmi also discloses a certificate. That certificate is at page 377. Now, your lordship will find, interestingly, I don't know, how this portal can, produce different certificates. with the same registration number. Now, let's page 377, if your lordship sees, my lord, kindly see, my lord, left hand, my lord, columns. My lord, your lordship will find that, my lord, ultimately the applicant is gender male. Date of incorporation is, my lord, 24th August 2023. My lord, which cannot be the case. Then your lordship will see, my lord, the right hand, my lord, columns. Now, my lord, there is, your lordship will find a mobile number given of a gentleman. My lord, this is apparently the applicant. My lord, this is not the mobile number of the resolution professional. This is an employee of, my lord, the corporate data company. Also kindly see, my lord, there in the right hand column, date of commencement of production of business is 24th August 2023. Incorporation 24th August 2023. Production 24th August 2023. Now, my lord, it gets curiouser and curiouser. If your lordship will now, my lord, come.
This male, who is male? Jagodamba.
Yes. Well, Jagodamba is the corporate data.
Male.
Male is Jagodamba, my lord, I would imagine. But, my lord, also, my lord, the applicant is male. The mobile number is male. Right. And, my lord, the whole object is to, my lord, show your lordship that it was not something that the RP did, although it is only the RP who could have applied.
Mr. Banerjee is for whom?
I mean, that one is to Mithru.
Oh, I see. You are Rashmi.
I'm Rashmi.
And you are RP. Very well.
Now, my lord, your lordship will see, your lordship will find the banking details.
Anybody for the Directorate of Micro Small?
Yes, my lord. Now, my lord, your lordship will find, my lord, the bank details thereafter. And then, my lord, following the bank details, there is employee details. Now, if your lordship, my lord, sees the bank details, State Bank of India, my lord, there's an IFS code, SBI and such. And then the bank account number is 00000000.
IFS code is also not there. It's SBIN 00000.
Yes. My lord, so IFSC code, their bank account is mentioned, but my lord, no bank account. Because no IFSC code number and no, my lord, account number. Then, my lord, kindly see the employee details. Employment details, male 1, female 0. Others 0. Total 1. My lord, this is the, my lord, company which is supposed to, my lord, have been granted MSME registration and is ultimately, my lord, pursuing this matter for the purpose of, my lord, ultimately resolving the insolvency. Now, my lord, your lordship will find that this is, my lord, completely discrepant, yet it appears to, my lord, have emanated from the MSME portals. Now, my lord, your lordship has seen that, my lord, the registration was granted till June 2022. Obviously expires thereafter, has to be renewed. It is done on the basis of self-declaration. Self-declaration is not made by the resolution professional, not the case that the application had preceded the commencement of insolvency. Someone with, my lord, a mobile number and, my lord, purporting to be a male, my lord, applies and, my lord, granted registration. 25th August 2023, 3 days after commencement of insolvency. And at the very same time, in the very same application, affidavit filed by, my lord, Rashmi, which, my lord, paints a completely different picture. But Rashmi, my lord, goes on to admit that, my lord, there is no bank account, there are no employees, one male employee. Now, my lord, so far as this is concerned, my lord, this is, my lord, the position of TENI. Now, my lord, we make a representation to the MSME authorities in these circumstances to cancel the registration because it becomes obvious that the registration is obtained on the basis of, my lord, misrepresentation, wrong self-declaration. Well, at that your lordship will find at page 404. Well, kindly now mark the date. My lord, this, my lord, representation is made on the 24th of February 2025. And my lord, the subject is request for cancellation of MSME registration. And without my lord going into my lord the details, well, if your lordship sees the grounds, A, cancellation on the ground of investment in plant and machinery more than the threshold limit. Then B, cancellation on the ground of closure of plant prior to my lord issuance of MSME registration certificate. C, cancellation on the ground of misrepresentation by company. D, registration granted to a non-operative company. And then misrepresentation and attempted circumvention of my lord IBC provisions to allot assets to related party. My lord, these are the broad heads. I don't want to, my lord, trouble your lordship with, my lord, the particulars. Now, my lord, so far as this, my lord, cancellation is concerned, this is, my lord, premised on a notification of, my lord, the MSME authorities. That notification your lordship will find is a notification, my lord, of, my lord, the government, which, my lord, starts at page 397. Well, the English version starts from page 401. Well, this is the basis on which we seek, my lord, cancellation. My lord, please come to, my lord, paragraph 6 or clause 6 at page 402. My lord, this is, my lord, this talks about the registration process.
Yes.
My lord, may I just read this? Registration process 1, the form for registration shall be as provided in the Udyam registration portal. My lord, in the meantime, there's a shift from UIM to Udyam. There will be no fee for filing Udyam registration. Aadhaar number shall be required for Udyam registration. Aadhaar number shall be of the proprietor in case of a proprietorship firm, of the managing partner in case of a partnership firm, and a karta in case of Hindu undivided family. In case of a company or a limited liability partnership or a cooperative society or a society or trust, the organization or its authorized signatory shall provide the GSTN and PAN number along with Aadhaar number. So, my lord, in case of a company, it has to be ultimately, my lord, the applicant will have to be, my lord, the authorized signatory of the company. My lord, who will apply along with the company's GSTN and my lord, PAN number, PAN and Aadhaar numbers. Now, my lord, here, my lord, at this point of time, the only authorized signatory could be, my lord, the resolution professional, no one else. But, my lord, it is not, my lord, his authorization, my lord, which has been the basis of the application, or, my lord, the company's PAN and registration. Then, my lord, if your lordship now sees, my lord, 6. In case of an enterprise duly registered with the PAN and any deficiency of information for previous years when it did not have PAN shall fill up self-declaration basis. 7. No enterprise shall file more than one Udyam registration. Then, my lord, 8 is important. Whoever intentionally misrepresents or attempts to suppress the self-declared facts and figures appearing in the Udyam registration or updation process shall be liable to such penalty as specified in section 27 of the Act. And then 7, registration of existing enterprises. All existing enterprises registered under EM Part 2 of the UAM shall register again on Udyam registration portal on or after 1st day of July 2020. All enterprises registered till 30th June 2020 shall be reclassified. The existing enterprises registered prior to such and such shall continue to be valid for a period up to 31st March 2021. And then your lordship will please see, my lord, also, my lord, clause 8. An enterprise having Udyam registration number shall update its information online in the Udyam registration portal, including the details of the ITR and the GST return for the previous financial year, and such other additional information as may be required on self-declaration basis. So the basis is self-declaration. Failure to update the relevant information within the period specified in the online Udyam registration portal will render the enterprise liable to suspension of its status. And then, my lord, clause 9, which provides for facilities and grievance redressal of enterprises. My lord, please see 9 sub rule 4. In case of any discrepancy or complaint, the general manager of the district industries center of the concerned district shall undertake an inquiry for verification of the details of Udyam registration submitted by the enterprise and thereafter forward the matter with necessary remarks to the director or commissioner or industry secretary concerned of the state government, who, after issuing a notice to the enterprise and after giving an opportunity to present its case, and based on the findings, may amend the details or recommend to the Ministry of Micro, Small or Medium Enterprises, Government of India, for cancellation of Udyam registration certificate. So, my lord, today, if you make a false declaration or a misrepresentation, my lord, on a complaint and upon affording an opportunity of being heard, it can be cancelled. And my lord, it is, my lord, on the strength of, my lord, these provisions that we apply for cancellation of the registration. Now, my lord, when we apply for cancellation of the registration, my lord, immediately thereafter, my lord, there's an inspection report, my lord, that is generated by, my lord, the MSME authorities that your lordships will find at page 448. This is, my lord, on the 3rd of April, 2020. But by the time we had also filed, my lord, a writ petition, my lord, for cancellation of the registration. But, my lord, before the writ petition could be taken up and heard, my lord, this was, my lord, the inspection report that was circulated by the MSME authorities. At page 448, my lord, that is volume 4.
Hello. John ji, इधर
My lord, please see, my lord, page 448. My lord, this is dated 3rd April 2025. It is issued by the General Manager of the District Industries Center, Paschim Bardhaman, and, my lord, also by the General Manager, District Industries Center, Paschim Bardhaman, my lord, who are all, my lord, authorities under the Directorate of MSME. My lord, subject is inspection report, and, my lord, this is what they write. My lord, this is a report, my lord, furnished with the Directorate of MSME West Bengal. Apropos the above noted subject and reference, I would like to inform you that an inspection has been conducted at Jagdama Industries located at such and such. The general observation of the inspection has been noted below. The unit has been identified by local people. There was no signage on the unit premises. Locals reported that the unit has been closed for some years. All the machinery have been already dismantled. No employee or worker was available at the unit premises. This is, my lord, the report. And, my lord, this is, my lord, made on 3rd April 2025. My lord, before, my lord, the writ petition that we had filed in this regard could be taken up for consideration. Now, my lord, immediately thereafter, my lord, this report was placed before, my lord, this honorable court, where our writ petition, my lord, came to be heard. This order, your lordship will find at page 449, the very next page. This report was placed before court. Your lordship will please see, my lord, first paragraph 2 at page 450.
This writ was also for cancellation of the MSME registration of Jagodamba.
Yes.
Yes.
Now, my lord, this is the order that is passed by the writ court on 4th April 2025. It starts at page 449. My lord, may I request your lordships to please have a look at 450. Paragraph 2. Learned advocate representing the state respondents has placed before this court an inspection report in respect of the respondent number 2, signed by the General Manager, District Industry Center, Paschim Bardhaman on 3rd April 2025, disclosing that on inspection it was revealed that the unit has been closed for some years. All machinery have been dismantled and no employee or worker was available in the unit premises. The report of the General Manager, District Industry Center, Paschim Bardhaman, dated such and such is retained with the records. Then, my Lord, Your Lordship will skip over and come to paragraphs 8, 9, and 10. The instant writ petition only revolves around the MSME status of respondent number 2. The inspection report of the General Manager, District Industry Center, dated 3rd April 2025, appears to have been forwarded to the Assistant Director in Charge, MSME, DFO Durgapur, for necessary information. Clause 9.4 of the notification, well, this is notification I showed you, Lordships. Clause 9.4 of the notification of the Ministry of Micro, Small and Medium Enterprises, dated 26 June 2020, mentions that in case of any discrepancy or complaint, the General Manager of the District Industry Center of the concerned district shall undertake an inquiry for verification of the details of Udyam registration submitted by the enterprise, and thereafter forward the matter with necessary remarks to the Director or Commissioner of Industries or Industry Secretary concerned of the State Department, who, after issuing a notice to the enterprise and after giving an opportunity to present its case and based on the findings, may amend the details or recommend the Ministry of Micro, Small and Medium Enterprises, Government of India, for cancellation of the Udyam registration certificate. The aforesaid provisions mentions about the complaint before the General Manager. In the instant case, the complaint lodged by the petitioner has been acted upon and a spot inspection has already been conducted. The General Manager, DIC, is directed to follow up the matter strictly in accordance with law and dispose of the complaint at the earliest. The final conclusion shall be made known to all necessary parties. As the provision mentioned here above requires grant of an opportunity of hearing to the enterprise, steps shall be taken strictly in accordance with the same. So, well, basically direct that on the basis of the inspection report, give them a hearing and then reach a final conclusion. Well, that is the order, my Lord, passed on 4th April. Now, my Lord, so far as this is concerned, my Lord, MSME, my Lord, issues a letter immediately thereafter, and this is very, very important. My Lord, please see a letter on the same date, 4th April 2025. That's at page 453. Page 453. Well, the date is 4th April 2025. This is the same date that the High Court, my Lord, proceeds to pass that order. My Lord, subject is, my Lord, subject matter is misrepresentation of facts in the Udyam registration certificate. Says, my Lord, this is reference to Udyam registration certificate, wherein the unit of Jagadamba Industries Limited, factory address such and such, at Bardhaman, it is reported to be a medium unit, is engaged in manufacturing. However, on physical verification of unit by DIC Paschim Bardhaman at its factory address, it has been found that the unit is closed for several years. All machinery have been dismantled and there are no employees or workers employed in the unit premises. The above facts have not been reported by you, and the existing UR, that's Udyam registration, clearly demonstrates misrepresentation of actual facts and the current status of the unit, not the writ, sorry. Hence, you are advised to apply to the following link for cancellation of Udyam registration. This will be done at our end on receipt of your application. Now, my Lord, interestingly, my Lord, following the order of my Lord, this court, the resolution professional then, my Lord, makes a representation. He says a whole lot of things. I shall take your Lordship through that. But, my Lord, what is very important is, my Lord, the system or the process is that once, my Lord, a company is declared to be insolvent, the CIP process is commenced against it, then, my Lord, the resolution professional has to furnish what is called the information memorandum. My Lord, this is, my Lord, for, my Lord, providing information to, my lord, all the stakeholders of the company in concern. My lord, creditors, my lord, financial creditors, my lord, others who may be interested, my lord, statutory authorities, etc. Others, my lord, who may have a claim, operational creditors. All of them, my lord, giving full details of what is, my lord, the status of the company, what are its assets, what is the value of the assets, my lord, who are the stakeholders, what is the, my lord, indebtedness, etc. Now, my lord, in the information memorandum that was published by the resolution professional, there was no mention whatsoever that, my lord, the company was MSME registered. Well, that information memorandum is on record. Well, I shall take your lordships through that. Well, I have 3 minutes left.
will you roughly how long you will take just for us?
I will not take very long, another 40 minutes or 45 minutes.
45 minutes?
I'll try to be, my lord, brief. Give me half an hour.
All right. And then when shall we keep it? Khata rakholo. Dujonei khata kholo. Tomorrow?
Yes.
No, Mr. Prasad, we can't accommodate everybody. It's impossible for us.
Well, let me.
Your matter, you go and do your matter.
Let me finish.
Let him finish. Then Mr. Banerjee, Mr. Mithyo is there.
Was red coat also, I took 5 minutes. I'll take 5 minutes only. I'll take 10 minutes. Let him finish tomorrow.
Yes, yes.
3:30 tomorrow. You do your matter and come back. All of you go out and do whatever is necessary. Dekho. Mr. Shah, Commander and Senior Advocate representing the appellants, resumes his argument but does not conclude. Paragraph lists the matter once again. Kalke date the marked kal dei to kichu 3:30. Marked 3:30 p.m. वैसे चुप करो जल्दी है तो खूबी बाल को please.
Mr. Charge the main one before the NCLT instrument.
The Supreme Court says I can't, my lord, agitate this question, my lord, before the NCLT. Mr. Banerjee insists I must.
Never raised all this point. I became the successful resolution applicant. Then thereafter, my lord, all this came.
Yes, my lord. My lord, that is.
He should have been. But he actually has made this argument in NCLT. I thought you were saying.
We'll be back in 3 minutes. Mr. Mukherjee, in 3 minutes we'll be back.
एक हो गया इसी में दूसरा लगा दें एनसीएलटी वाले जो तुमको दिए थे उसको कर दे
दिया था वही इधर ज्वाइन किया
और दूसरे
Stop dates. Item number 88. That's it.
Yes, my lord, there are, my lord, two appeals. My lord, 1491 and 1492. My lord, both arise out of the same, my lord, order. Two writ petitions, my lord, had been disposed of, my lord, by one common order, my lord. Now, my lord, the challenge, my lord, was to, my lord, downgrading, my lord, the writ petitioner from an approved supplier to, my lord, RDSO development, my lord, supplier, which
25.
correct. So, my lord, I don't get, my lord, the entire pie, my lord, to bid for. And, my lord, I have from the approved suppliers list gone to, my lord, the developer list, my lord.
Right. Yes.
Now, my lord, the only ground on which, my lord, my clients, my lord, have been downgraded is because my clients, my lord, have sourced, my lord, one of the components from its factory in Jabalpur and has not sourced it from, my lord, Slovenia. My lord, the client, my lord, is a 50-50 joint venture of, my lord, Jupiter Wagons here and, my lord, Koves of Slovenia. The QAP, my lord, Quality Assurance Plan, Revision 2, which was applicable at that point of time, my lord, provided for the drawings, my lord, which had to be, my lord, followed, my lord, for the purposes of supply. And, my lord, source had been indicated, my lord, as, my lord, Slovenia for this particular component. Now, my lord, the question that arises is, my lord, if, my lord, I do not take it from the source, and the source, my lord, is not and cannot be a design specification, can there be any downgradation? The learned single judge did not go into that question at all. Our specific case was, there's a drawing mentioned in QAP Revision 2. We have, my lord, manufactured, my lord, that component, my lord, in Jabalpur in accordance with that drawing. All these products have been bought, my lord, by, my lord, the railways after testing, after, my lord, inspection, without any complaint as to quality, and have been utilized. My lord, where, my lord, there is no finding that there is a design flaw or that any particular product, my lord, was defective, there is no question of downgrading. The learned judge, with the greatest of respect, has said that is not necessary. If QAP Revision 2 provided for source of supply as Slovenia, you had to buy it from Slovenia or source it from Slovenia. And the very fact that you did not do it means that there was a violation of a contractual specification which warranted and justified, my lord, this decision of downgrading. My lord, I'll cite one recent Supreme Court decision. My lord, even if it is a violation of a contractual, my lord, clause, my lord, that cannot be a ground, my lord, for, my lord, downgradation or blacklisting. In effect, I'm taken out from, my lord, the main sphere. I'm put into 20%. But, my lord, be that as it may, my lord, I'll demonstrate before your lordships, my lord, that this sourcing, my lord, has nothing to do with my lord specifications or design, and therefore could not have been the basis for downgradation. I've prepared a list of dates to move fast, my lord. My lord, your lordships kindly take it. Other side ke liye. My lord, the first date, my lord, kindly take. It's, my lord, 16th March 2023. The Research Design and Standard Organization, RDSO, approved the Quality Assurance Plan, QAP Revision 2, QAP Rev 2 of the appellant for brake disc formula. LHB stands for Linke Hoffman Busch. These are passenger wagons, my lord. Coaches conforming to RDSO specification, Revision 1. Now, my lord, kindly take the second note, and this is very important. RDSO at the time of approving the QAP and the drawing has clarified that above approval is for general design features and controlling dimensions. Other design details and dimensions have not been checked. Suppliers, manufacturers should ensure that they are in conformity with contract drawing specifications and QAP. Hence, QAP only relates, this is my comment, related to design features. QAP only requires conforming with the drawing specification of the items. Kindly take, my lord, the covering letter, page 58 first. Volume 1, my lord, that's in volume 1. I just want to show that to your lordships. 16 March 2023. Now, my lord, I know it's 150 to 200 pages or whatever, my lord.
I persuaded the Chief Justice. That was the practice on the original side. Same practice has now been introduced appellate side. But if you tie up all the volumes together,
Then it's defeated, my lord.
Defeated total. Sorry, which page?
My lord, page, my lord, 58. Though, my lord, I've been told, my lord, with advancing years, I should do weights so that, my lord, the muscle mass, my lord, does not, my lord, disintegrate.
Yes.
My lord, kindly take page 58, my lord. This is, my lord, 15 March 2023. Kindly see, my lord, the subject. Approval of QAP, my lord, break this so-and-so, revision 2, dated 5th September 22.
58.
My lord, page 58, volume 1, my lord. Paper book, volume 1, my lord. I don't know what's being given.
Stay petition, I suppose.
No, my lord, volume, paper book's there.
Paper boy আছে can দিলে কেন?
Paper book আছে তো? My lord, we filed it last day, my lord. They are bound volumes, my lord. It's be easier, I think.
They won't be stitched together at least.
No, that's what I meant, my lord. যাও না একটু দেখিয়ে দাও তাড়াতাড়ি যাও ভলিউম 1 দেখান আমাকে আমি দেখিয়ে দিচ্ছি 1491 এর দিন 1491 volume 1 my lord it's easily handleable my lord kindly take my lord দুটো আপিলের একসঙ্গে আছে আরেকটা থাকবে এমএটি দেখান আমাকে আমি দেখিয়ে দিচ্ছি এই স্টে পিটিশন সরিয়ে নিন, এটা মানে এখন এখানে
রাজকুমার আছে এইগুলো। এই শোনো শোনো, এইগুলো দাও বেড়ে দেবে। Yes.
My lord, kindly take, my lord, page 58.
Yes.
My lord, kindly see the subject. Approval of QAP number break disc 01 revision 2 dated so and so, and assembly drawing number so and so for manufacture and supply of standardized brake disc for LHB coaches to RDSO specification number so and so dated June 2021. Reference so and so. In reference to the above, please find enclosed herewith a copy of duly approved QAP so and so for manufacture and supply so and so coaches. Now, my lord, kindly see the next. For your works at Richal Industrial Area, Jabalpur, Madhya Pradesh, India. So, my lord, what I manufactured there has to be, my lord, as per that, my lord, drawing. My lord, that for, my lord, disc so and so specification. Above approval is for general design features. Kindly note this, is for general design features and controlling dimensions. Other design details and dimensions have not been checked. Suppliers, manufacturers should ensure that they are in conformity with what? Contract drawing, specifications, and QAP. Notwithstanding this approval, firm is wholly and completely responsible for quality, online performance, reliability, and life of the item supplied. Any alterations, amendment, revision of this QAP stroke drawing will render this approval void automatically. In such case, fresh approval shall be obtained. Now, kindly see, my lord, the QAP. Kindly come straight away, my lord, to, my lord, section, my lord, D at page 71. Lordships have that. Heading is section D. Details of sub-assemblies, components manufactured in-house and outsourced. Kindly see item name, brake plate, so and so, drawing number. Kindly have a look at the drawing number. KE 01012308. Then, my lord, details of components, sub-assemblies purchased from RDSO approved vendors. My lord, nail here. There is no. Then, my lord, kindly come to the next. Details of items outsourced from other than RDSO approved vendors. Now, my lord, kindly see. Item, my lord, 6. Brake plate casting. The drawing number is the same. Lordships have that. As, my lord, brake plate, which is in, my lord, the first table. KE 010123-08. Kovis, Slovenia, as per JWL Kovis audit plan. JWL Kovis is Indian. As per their audit plan, we'll get it from there. And it'll be as per this drawing. So, my lord, now, my lord, kindly take the drawing which is at page 195. Volume 2. My lord, this is in volume 2, page 195. This is, my lord, the drawing. Your lordship will find, my lord, the number.
Should be here. It's cut off. Every drawing has cut off.
My lord, unfortunately, the drawing number, my lord, in the right-hand side bottom, my lord, I think is cut off.
KE 0101 can be figured.
Yes, my lord. My lord, I'll show it from, my lord. Dekhe na ache. I was hoping at least, my lord, your lordship's brief would be complete. Stay petition ache. But, my lord, the number is the same, my lord. I'll My lord, show that. So, my lord, I had to make supplies, my lord, in accordance with, my lord, this quality assurance plan and whatever specifications were there in the tender documents. Now, my lord, what happens? My lord, between 18th May 2023, my lord, to, my lord, 27th May 2024, my lord, we sought a revision of the quality assurance plan. My lord, same drawings, my lord, had been upgraded, etc. And we also mentioned that the sourcing will be now done from, my lord, our Jabalpur plant. Because, my lord, it was set up under the joint venture with a collaborator, Covis. Now, my lord, there were several, my lord, tenders. Kindly come to, my lord, list of dates, page 2. My lord, item 5, my lord, is, my lord, 27th May 2024. I'm sorry, my lord, volume 2. If you can find the drawing showing somewhere. Is it showing? It's a stay petitioner, volume 2.
Should be volume 3.
Volume 3 type to work on. Stay petition. Stay petition. Stay petition. Stay petition. যেটা প্রথমে বার করেছিলেন এইখানে volume 3 page 405. I just want to show that drawing, my lord. It's the same number.
No, we take it.
Yes.
All right. Cheers up.
Now, my lord, in the list of dates, item 5, my lord, will show that, my lord, this was our revision 3. My lord, we had an approval of revision 3, and that's, my lord, at page, my lord, 90 to 116. My lord, my lord, I don't want to place that. This revision 3 came, my lord, for which the main difference was sourcing will be from India.
And that was approved.
That was also approved. Now, my lord, 29 July 2024, my lord, after, my lord, this approval, my lord, we get, my lord, a letter requesting the appellant to submit the percentage of local content quoted against the tenders mentioned therein, as well as the details of the outsourced component other than Make in India. Now, my lord, Make in India policy, my lord, was in force. So, my lord, local content supplier grade 1 would be somebody whose local content was, my lord, more than 50% of the product. My lord, even without this casting, my lord, our content was more than 50%. Admitted fact, no dispute. But what they did was, now, my lord, kindly have a look at, my lord, so we responded. Now, what were those tenders, my lord? My lord, they were, my lord, kindly have a look, my lord, at item 6, my lord, of the list of dates. I have given the list of tenders. Pages, my lord, 2 and 3. My lord, they started, my lord, tender number from 19 July 2023. That's the last one, my lord, item 9 of the tenders. And, my lord, the last of the tenders is item 1 at page 2, my lord, 2nd January 2024. So during this period, my lord, we supplied under these tenders after meeting all quality requirements, which were purchased by the railways after testing and inspection. And there was never, ever a quality, my lord, dispute or complaint. So we pointed out that we had, my lord, supplied under these tenders, and, my lord, we provided the purchase orders, my lord, against these, my lord, tenders.
But all these were before 27th May 24.
Correct, correct. Before, my lord, QAP 3 is, my lord, my argument will be very simply that, my lord, source, my lord, is immaterial. Because there's not even an approved source. As long as the specification in QAP, my lord, is design specification is met, that's all that matters. And the tender, my lord, further specifications.
And no complaint about the performance.
Complaint. And taken after inspection, after, my lord, testing, and, my lord, full payment made. Now, my lord, we also provided the purchase orders. Now, my lord, this is very important. My lord, kindly take page 131, my lord. It starts from page 124. This is the table, my lord, of the purchase orders, which we gave here. And we annexed, my lord, the purchase orders also. My lord, kindly take page 129.
Volume 1.
Volume 1. Which will show, my lord, source, my lord, is immaterial. Kindly have a look in their own purchase order. Page 129. This is volume 1, my lord.
Yes.
Kindly come to page 131.
Yes.
May I read, my lord, item 14? That's the first one. JWL Covis India, Calcutta have to ensure list of components and their sourcing as submitted by the firm in tender as under indigenous, brake plate machining, hub forging, so and so, so and so, so and so, so and so. B, imported, fastener, sets, so and so, so and so, so and so. And then, my lord, kindly come to clause C, 14C. That's the last line of that table in under clause 14. Brake plate casting will be either indigenous or imported from.
Are we concerned with brake plate casting?
I'm grateful. Sources and material. They look at my joint venture partner, so they don't even approve Covis. They only say this drawing. So, correct purchase order chilo.
146. That is
Then, my lord, yeah, and it was amended, no? Now, my lord, page 146, my lord, is another purchase order. And this is, my lord, dated 18th of March 2024. My lord, kindly take, my lord, I'm pointing this out because, my lord, there was a modification of this which I'll just hand up. So that, my lord, later on, my lord, it's not said that I have not made the correct submission before court. My lord, kindly have a look. My lord, item 12, my lord, about in that table, my lord, last 4 lines, brake plate
129.
147. The purchase order starts at 146. It's dated, my lord,
18th March 2024.
18th March 2024. Just before, my lord, QAP 3. My lord, kindly take note 12 at page 147. Sit. This is where is this? Now, order 41. You have it separately. Now, my lord, kindly see brake plate casting. My lord, 4 lines from the bottom of 4th line. imported from Covis for this purchase order.
Yes.
So this would suggest you have to import it. Now, my lord, I must tell your lordships, my lord, after this order came, my lord, after that there was another, my lord, decision taken to ban us. My lord, that was, no interim order was granted. We went on appeal and there's a stay of that. My lord, in that, my lord, we have disclosed, my lord, the modification. This is the stay petition. I'm just showing it, my lord. I'll put in an application if necessary. The judgeship. Give a
This is
copy
this-
to the other side.
This is the stay petition in that appeal.
Yes. Shall also come, my lord, before your lordships. And kindly note this, my lord, there's not even a choice. Imported is changed to, my lord, indigenous. This very purchase order.
This is 24th July.
Correct. 25th July 2024.
25th July 24. Yes.
My lord, the purchase order otherwise, my lord, was 18 March 2024. আছে তো আছে তো হ্যাঁ আগেরটা হ্যাঁ হ্যাঁ দিয়ে দেবো কপি একটা দিয়ে ফটোকপি করে এক্ষুনি দিয়ে দেবো Now, my lord, we disclose the information. Kindly see the list of dates. Now, three things are important. My lord, this product before supply, my lord, inspection is taken. My lord, tests are carried out. And then, my lord, it was accepted. That it conforms to all specifications, there is no defect, infirmity. And they bought the whole consignment and paid. And there is not even one complaint, my lord, of any defect. Now what happens? My lord, we, my lord, disclose, my lord, kindly take list of dates, item 7, 12th August 2024. The appellant submitted the information requested by RDSO in its letter dated July 29, 2024. The appellant informed that it has not imported any other component except fasteners to manufacture the brake disc, pointed out that since the cost of fasteners is low, local content level achieved is greater than 90% against the minimum local content requirement of 50. So, my lord, whoever has more than 50%, my lord, gets, my lord, a preference. So I was not gaining anything. I could have understood. I didn't have 50 otherwise. By doing this, I was gaining. I'm not gaining anything in the competition. And my lord, my products were technically sound, no dispute. I had the lowest price because I had greater than 90% local content. So, my lord, railway should be happy that they're getting products manufactured in India under Made in India scheme, Make in India scheme policy, which satisfy all technical specifications. Now, my lord, after, my lord, we disclose this, 19th August, my lord, they sought a clarification from us. My lord, I must show this, page 120 of volume 1. My lord, kindly take C. My lord, it is also mentioned in the letter that firm has not imported any other component except fasteners to manufacture the brake disc to RDSO specification, whereas QAP submitted by firm and approved by so-and-so referred to has 6 imported components, including brake plate casting. Lordship has that? and was advised to submit detailed clarifications, etc., etc. Then, my lord, list of dates, item 9. The RDSO issued a letter requesting appellant for a meeting. Then a further letter, my lord, whether another item has been outsourced or manufactured. Then, my lord, comes, my lord, 20th September 2024, my lord, where we provided, my lord, all, my lord, the clarifications and enclosed the purchase orders, which I've just shown to your lordships. That document, kindly have a look at page 123. We write to you in reference to the letters dated so and so issued by your office requiring us to furnish some details. Please find below our response to your observations. Your office had sought for the copy of purchase orders awarded to a company. Please find attached to this letter copies of relevant purchase orders awarded to a firm and collectively marked. So we, my lord, given those. Then, my lord, our company sought clarification from your office about the term fasteners in the table, etc., to which you has clarified is required on purchase order following the said table with purchase order count. Then sought a clarification on submissions, etc. We were asked to, which we provided. Then, my lord, kindly come to 4. We state that the brake disc at 125 manufactured by a company contains the brake plate casting stroke item ring along with a single set of fasteners. The brake plate casting is based on the manufacturing application of our technology partner so-and-so. Therefore, as per the latest QAP, our company is permitted to import from so-and-so, as well as manufacture in-house the brake plate casting so-and-so. While initially our company was importing the brake plate casting from Covis, subsequently after successful transfer of technology from Covis, and also the training of workforce by Covis, we are now manufacturing entire requirement of so-and-so, so-and-so. And then, my lord, we go on to state, my lord, in para 14, with active guidance and cooperation of RTISO specifically, JWL Covis has collaborated with Covis so-and-so and set up state-of-the-art production facilities, including foundry for manufacturing, in reduction of prices by almost 2/3. Now, my lord, after receiving all this, they issue, my lord, a show cause notice. Now, kindly have a look at the show cause notice. 14 November 2024. At volume 2, my lord, page 154. Kindly see VDA letter at reference number 3 above. The details of sourcing of raw material and local content was asked from the firm. The firm has stated in reply VDA reference 1 above that we would like to inform you that we have not imported any other component except fasteners to manufacture so-and-so. Moreover, as per QAP approved on so-and-so and valid till 27th May 2024, following items have to be imported. Last is, my lord, as I said, brake plate casting, so-and-so. From the above, the firm has not sourced item so-and-so above from Covis as mentioned and approved and not followed the approved QAP. Therefore, it is advised to explain within 30 days why penal action should not be initiated. Kindly mark the paragraph. As per para 4.2, version so-and-so for not following the approved QAP for sourcing of raw material for manufacture and supply. Now, my lord, we immediately replied to this, page 155. Next page, my lord. My lord, we point out, my lord, that we now have, my lord, QAP 3 approval from 27 May 2024, which, my lord, says, my lord, it's in India. Then, my lord, we also point out, my lord, as to why, my lord, this should, my lord, be withdrawn. My lord, summary, my lord, is at page 158. Most importantly, my lord, kindly come to, my lord, clause I. Therefore, we appeal to your kind self to withdraw your office letter due to the following reasons. Brake disc castings produced in Jabalpur are as per approved KOP revision 2.
158.
My lord, 158. It's part of, my lord, 155. 155 is the reply, 6 December.
Therefore, we appeal. Yes.
Yes. Then JW has not supplied any standard substandard products to Indian Railways, followed brake disc specification and met all requirements and leading suppliers, etc. And my lord, employment, my lord, we have additional employment of 150 people because of, my lord, this collaboration which we have. Now, my lord, what happens, my lord, we, my lord, get an order on 2nd of January 2025, my lord, downgrading us. This is the letter, my lord, which is, my lord, important. Show cause notice, my lord, 1160, my lord. The reply received has been examined. It is noted that firm's clarification on subject matter is not satisfactory, therefore not acceptable. Firm has been downgraded from list of approved vendors to list of RDSO vendors for development orders with immediate effect as per para 4.2.1 so and so ISO document. Vendor changes his approved status for manufacture so and so. Firm can appeal to special so and so so and so. So we get, my lord, this letter. Now, my lord, 3 points I wish to make apropos this letter. My lord, first is, there is, my lord, no finding. And that will become apparent, my lord, when I read, my lord, 4.2.1.1. With regard to seriousness or the nature of the deficiencies or the effect on quality due to in-house manufacturing. There is none. Nothing, not a word spoken, my lord, about quality. Then, my lord, 4.2.1 has to be read, my lord, with another clause, which is 5.1.3b2 and 3, where, my lord, it says there has to be, my lord, certain findings that it fails in any of those parameters, that is quality and efficiency. And, my lord, the severity of the action taken, because here it is in perpetuity. I'll show, my lord, the order. There's no time limit mentioned. Just placed it. There's no time limit mentioned. Has not arrived at any fine that it does not conform with any of the. Now, my lord, there's an appeal provision in the tender documents. So we preferred an appeal. My lord, on 23rd January 2025. After filing the appeal, my lord, we filed the first writ, which is on 10th February 2025.
During pendency of the appeal.
Yes, no action was being taken. So, my lord, that's item 16, my lord, in the list of dates. My lord, item 17, my lord, a report was directed to be filed. Huh? Yes. And then, my lord, page 18, directed the respondents to consider and dispose of the appeal of the appellants in accordance with law. Now, my lord, without hearing us, the appellant passed an order. The appellate authority passed an order. So, my lord, that was also challenged. And, my lord, a direction was given, my lord, that we had to be, my lord, heard. Now, 6 June 2025, my lord, is, my lord, the appellate authority order. And my lord, I just wanted to point out, my lord, there was an interim order that I'll be during all this time, that I'll be treated, my lord, as an approved vendor. While this challenge, my lord.
Justice Sen.
No, Justice Sinha. Right. Now, my lord, kindly take the appellate order. My lord, it starts at page, my lord, 649, volume 5, page 649.
Yeah, that's right.
My lord, I just wanted to indicate one thing. I've given, my lord, NB my comments, my lord, to assist your lordships.
Very helpful, Mr. Very, very helpful. Yes.
My lord, Dr. Shankar Ghosh, my lord, used to do that.
Very helpful. This is your argument.
Yes.
So, very helpful.
Now, my lord.
And you're just on a lighter note. Just a little while ago, you just saw your argument created a big bang.
Oh, there. But I'm sure that wasn't in appreciation of the arguments.
Yes. 640.
My lord, 654. It is seen that under the then prevailing QAP revision 2, the appellant was under an express obligation to quote and supply castings sourced from foreign original equipment manufacturer, namely Covis. My lord, I don't know where this is coming that I have to quote on this basis, because I have not quoted on that basis. Make in India, my lord, I said will be manufactured in India. The admitted departure from this stipulation, wherein the firm instead used in-house manufactured indigenous casting, constitutes a significant deviation from the approved QAP. Such a deviation is contemplated under the governing clauses of ISO accredited vendor approval guidelines, qualifies as a major non-conformity, thereby attracting penal consequences. And then, my lord, this is quoted, and kindly come to clause 4 at page 657. It is conclusively established that the appellant supplied materials without adhering to QAP approved on so-and-so and the associated technical specifications. Well, there is no finding on technical specifications. This constitutes a clear violation of the vendor approval framework, which mandates strict compliance. Now, my lord, I pause here. Lordship recalls 3 tables in QAP 3. What I'm getting from abroad doesn't have RDSO approval. The 3 other tables, my lord, has, my lord, the drawing number. RDSO approved is blank because I'm not getting it from any, my lord, other supplier. And, my lord, the 3rd table only gives the sources. QAP 3. This was given in 23, after which I built up my plant, my lord, and was in a position, my lord, to supply. Now, my lord, in the light of foregoing, etc. So, my lord, we challenge this. We challenge this. Now, my lord, the grounds of challenge, my lord, are there in item 21. My lord, from the first NB. This, my lord, will respond number 4 has not arrived at any satisfaction or finding that the in-house manufactured brake plate casting has any effect on the quality of the product. There is no finding as to the seriousness or the nature of deficiencies of the in-house manufactured item. Respondent number 4, despite recording the submission of the appellants that supplies were in conformity with the extent RDSO specifications, has proceeded to penalize the appellants. The respondent number 4 has not arrived at any finding or provided any comments or details with respect to non-conformity of brake disc casting to the technical parameters as provided in clause so-and-so, of vendor changes in approved status. No reason has been given as to why there is a major non-compliance, as such prerequisites, etc. Now, just one portion I want to show. My lord, 2.4, my lord, of, my lord, the appellate order, page 650, which I have, my lord, quoted as one of my challenges, so that your lordships, my lord, have this. para 2.4 at page 650. It was further submitted that the supplies made were in full conformity with the extent RTSO specifications and that no breach had taken place which would justify the downgrade. A specific case, it's as per specifications. Then, my lord, we were downgraded. My lord, then, my lord, we filed, my lord, writ petition, my lord, 14430 of 2025. And that was, my lord, dismissed by an order of 26th August 2025, which I placed, my lord, on the last occasion. I can.
The impugned order.
The impugned order.
Yes. Both the writ petitions were.
Yes.
Yes. What we need to see is next occasion, next day.
Clause 4.1 and
4.2.2. That.
Yeah, and 5. I'll just show that. That is, and the specifications and the testing which happens.
When?
My lord, any day, tomorrow, day after, any day that suits you. I'll tell your lordships why, my lord, I'm, my lord, being a bit persistent on this. My lord, after this, the impugned order here, my lord, first they, my lord, go ahead and, my lord, ban me completely. Then, my lord, after that got stayed, one of the purchase orders provided that if I lose in this writ petition, my purchase order would be cancelled. After the last hearing, they've cancelled one purchase order.
Milord, tomorrow and day after tomorrow I have some difficulty. Milord, I'll have to go out of Calcutta for that SIR purpose.
Sir.
On Friday at any time, Milord.
SIR, the notice has been issued today for affidavits, unless it's some other matter. Well, I've been following that.
Kindly take it on Friday, Milord.
Roughly how long you will take?
My lord, another 40, my lord, 3 cases I need to cite. Show those 2, my lord, clauses.
Let Mr. Mukherjee complete on Thursday. Your junior will be here. We'll hear you on Friday.
My lord, then kindly years on Monday us. We'll let senior complete on Thursday.
On Thursday, Thursday.
I'll finish on Thursday.
Thursday, কখন হবে? না, 3:30 করো না। উমেশ্বর যাবে প্রাণ। 12:30 দেখো। তাহলে
ঠিক আছে।
12:45 12 o'clock.
On Thursday, my lord?
Monday,
Mr. Mukherjee, Commander and Senior Counsel, representing the appellant in these two appeals, resumes his argument but does not conclude. Paragraph lists these matters once again. Duto matter hi ache to bhai?
Yes, both are in the list.
Thursday date though, marked 12 p.m.
Obliged.
For our reply, we don't have
Yes.
Monday, my lord.
That order will record on Thursday.
Grateful, my lord.
On Thursday, none of you will be here.
No, my lord, I'll be there.
You will be there.
I'll be there.
Thank you.
I'm so grateful, my lord.
Sure.
Only, my lord, we will be allowed to argue on Monday.
By Friday, he said he's available.
No, my lord.
What? No, he says he is available. You are saying.
My lord, actually, the issue is, my lord, I have argued this matter in the single bench, my lord.
Yes.
My lord, I would love to argue before your lordships also, my lord.
Argue on Friday?
My lord, I'm not there on Friday, my lord.
We'll see.
On Monday.
Only your lordship considers that will allow us to argue on Monday, my lord.
Persuade Mr. Mukherjee.
My lord, sir will allow. He is very generous, my lord. I'm so grateful.